of a bail application, my lord. The connected matters, my lord, fixed on 20, my lord. Come up along with my lord.
Bail application relating to less than 7 years matters only. Otherwise, you'll have to mention before.
More than, my lord. More
Less
than,
than
my lord.
7
My
years.
case more than 7.
No, less than 7 years.
More
only.
than and less than, my lord, it is mentioned.
Huh? Okay.
And my case more than, my
All,
lord.
only special acts you
It's
cannot
not
mention
here, my lord.
before me.
Yes, my lord.
All right.
On 20, my lord, obliged.
May I please? I had filed a bail application on 7th of March. Case is number not yet listed, ma'am. So, BA, my lord, maybe come up tomorrow, my lord.
When do you want?
Tomorrow.
Tomorrow is hearing day.
On 7th, I have filed.
Day after tomorrow? Tomorrow is hearing day, no?
The
Day
day
after
after
tomorrow.
Then another matter, my lord, then I of a criminal appeal, my lord. So 1 year is pending. So the I may be come up for any day of next week, my lord.
Any day of next?
Next week, my lord.
Next week. All right.
24. It was 20. I will.
I take for leaking of a criminal for consideration of the interim act. The last location is of 10 feet. It is directed to be distributed each week. So the date that
When you want.
on 19.
Maybe, Lordship, my lord. I beg to mention a criminal petition in order column, my lord. I am the respondent, my lord. Petitioner filed the criminal petition file and got the stay order, my lord, in the TBS Act, my lord. So, my lord, this
Criminal petition in the orders column.
orders column, my lord.
You want it to be listed? When do you want it to
My
be
lord,
listed?
Friday, my lord.
Friday.
Hello, Lord.
The listing of a bail hearing matter earlier later on 20 February. I am not an interim.
When do you want?
Any day this week 20.
21st.
I beg to mention for listing one urgent bail application, Lordship, unlisted motion.
Bail application.
Bail application.
Pertaining to special acts?
No, special like Lordship.
When do you want?
Today is itself, Lordship.
Today? Today, no. Not possible.
Tomorrow then, Lordship.
Not tomorrow, day after tomorrow. You are behind bars for how many days?
Already 1 month, Lordship.
1 month. What is the offense?
This is the civil nature case, purely on civil nature case.
Oh,
That's
420.
why.
Okay. Day after tomorrow.
Always, Lordship.
Bail petition. On motion. AB? All right. Not tomorrow, day after tomorrow. Under which sections? POSCO. Appeal POSCO. When do you want? All right.
My pleasure. Sir, I beg to mention for listing on criminal appeal. So last listed on 28th October. Can it be on 24 orders column?
Criminal appeal in the orders column. Bail application. Under which section?
I is there. POXO is there.
POSCO. When do you want?
On Thursday 20.
Thursday is a
Orders
hearing
column.
day.
Lordship on Friday.
And now after this, not anymore on in this week, okay?
Okay.
But this is the last matter to be placed in this week.
On 20. Masul.
I beg to mention one criminal petition to be listed in the
Criminal petition, did yet? Sir, was one I was next week. Criminal petition next week.
May I please, your lordship? I'm begging for the inclusion of BA number 642. The accused is behind the bars for 45 days. May be taken on 19th, Your Honor, day after tomorrow.
45 days.
45 days.
Under which sections?
It is for presumption of death, Your Honor. 113. 118.
Presumption of death?
Presumption of death.
Under which section?
87, Your Honor.
87 BNS.
Not the special act, Your Honor.
Huh? 87 BNS.
Yes, Your Honor.
BNSS or BNS?
BNS, Your Honor.
Kidnapping, abducting or inducing women to
Your Honor, it is for dowry, assault for dowry. 87, Your Honor, of BNNS. Pardon, Your Lordship. And the 113A IPC, Your Honor, presumption of dowry debt.
there's nothing dowry there under 87 of the
No, no,
PNS.
87 is for assault for dowry, Lordship.
Kidnapping, abducting or
No, no, no,
inducing a
it-
woman to compel. This is section 87 of the BNS.
Give me a moment, Your Honor. I'll clarify.
May I please?
Hmm.
Lordship, I beg to mention criminal appeal. I is pending, my lord.
Hmm?
Criminal appeal, my lord. I
I is pending criminal appeal under which sections?
under section 21B, my lord, NDPS,
21B.
intermediate one.
You are behind bars for how many years?
7 years. My lord, behind bar for 91 days, my lord.
Convicted.
Yes,
When do you want?
24, my lord.
24th?
Yeah.
Next week?
Yes.
Yes. On 24th, yes. 24th free day, huh? One day. Hmm. 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 CDS call for is item 40. CDS call for is not received. Issue reminder. List the matter on when do you want? Are you on interim bail?
No.
List the matter on short date on 24th.
Please, Your Lordship, I beg to apply for listing a bail in connection with criminal appeal for day after tomorrow.
Under which section? Criminal appeal?
324 behind the bar 1 month.
What is the conviction for how many years?
1 year.
1 year conviction.
Only.
Tomorrow, not tomorrow, day after tomorrow.
Yes.
Cannot hear you. Put on the speaker. Day after tomorrow, tomorrow. There's another matter fixed tomorrow.
May I please, Lordship? I apply for listing of a criminal appeal, my lord, under 376. The prisoner is behind the bar for 3 months. 3 months. Day after tomorrow, my lord.
Criminal appeal
Fine. 10 years
under
conviction.
section 376 IPC.
My lord.
Not day after tomorrow. Come on. Next week.
Obliged.
May I please?
Hmm.
I beg for criminal petition.
Hmm.
The
Criminal petition,
criminal
not on 21st. 26th.
May I please, Your Lordship?
Hmm.
I beg to mention item number 42 be kindly adjourned for the day and
Item 42.
yes, sir.
It's a bail matter.
I beg to mention, Lordship, to kindly continue the interview.
See, why? We have received the CD. Won't adjourn.
But the CD may kindly be retained for.
Why should we
Lordship,
retain the
senior
CD?
is out of-
Investigation is going on.
Lordship, senior is out of now.
Learned Counsel Mr. M. Biswas is out of station. CD is received. Release the matter on Ekopta data detail. 24th. CD to be retained till 24th.
Lordship.
May I please, Lordship, I beg to mention, listing for mention, Lordship, 1IA in criminal appeal, Lordship.
1IA in criminal appeal.
Yes, Lordship,
When
for
you want?
orders. Lordship, day after tomorrow, Lordship.
No. What kind of appeal is this? Under which sections?
Lordship, section 415, surplus 2 of BNSS.
What section?
Appeal under section 415, surplus 2.
No.
Sentence, Lordship, 326.
326.
And 333,
333.
147.
326. No. Next week, not
Next
tomorrow.
Public.
26 March.
for listing of criminal appeal. 6 limit.
Criminal revision petition. Date next week or date at a detail. 27.
Also similar period, one criminal petition.
27th.
25th, Lordship, 25th.
It is a criminal petition, isn't it?
Yes.
25th is a hearing date on 27th. Hearing day, Hannah? 26th, on 26th. Sorry, can't hear you.
Appeal.
Appeal.
Sorry.
What?
Item 11 feet of-
Appeal, you want the appeal to be listed?
And it was certified for 5 years. End of it. And
5 years under which sections?
this was 5 years.
When is his exam?
24.
24, day after tomorrow.
Lordship, item 10, CD is not there. And interim
Item 12,
10.
10. CDS call for is not received, issue reminder, list the method.
Interim. 10, why is good?
Interim order shall remain in force till then. Item 10 is motions.
Mohibul.
So, just a moment. Item 10. Interim order. Oh, ठीक है सर. Oh, yes.
Lordship, for listing one criminal petition, any date.
Criminal petition data did of next week, but our episode we got did 28 March. 47. Okay. You do not have the CD. We do not have the CD. Update CD as has been called for is not received. Issue reminder. Okay. Learned Counsel, Mr. B.M. Chaudhary is present. Learned Additional PP. Mr. K. Bush is present. CD is not up to date. Send back the CD. Call for the up to date CD. List the matter on. Are you on interim bill? 28. 46 and 47. Oh, sorry. 28 of March. Is it okay?
May I please your lordship?
Mm-hmm.
Your lordship, I beg to mention a bill application matter for tomorrow. It's an urgency in matter. Your lordship.
Why the urgency?
It's about a petitioner. She's an 67-year-old and she's behind bar from 16 Feb.
What is the offense?
Section 483 in BNSS Act.
Offense.
Ma'am, drugs like heroin.
67
And
years old.
And yes, 67 years.
Are you sure she's 67 years old?
Yes. Your Lordship.
Not tomorrow. Day after tomorrow.
A criminal petition has been filed on 13 Lordship. I'm playing for listing on the day after tomorrow Lordship. Because against me, proceeding under 446 has been initiated because of non-appearance of the accused, for which I stood as surety.
When is the date fixed?
Date 20 Lordship, Thursday, in the trial court.
Tomorrow. Okay.
Tomorrow. 19.
No, not tomorrow. Day
Nine-
after
9
tomorrow.
Much better.
Date.
May I please your lordship? The section is 108 of BNS. So abatement of suicide, your lordship.
Oh, abatement of suicide date or due date next week?
Lordship.
No. Next week. 26 March.
Your Honor,
No.
19th, your lordship. 19th,
No.
your lordship.
No. 26th of March.
He's behind the bars for a very long time. There is a cross case,
How
your
long he's
lordship.
been behind bars?
He's 45 days, your lordship. And there is a cross
No.
case.
There are other urgent matters here.
Lordship,
Other
the
urgent
person
matters.
died, a person had died 49 days before the
No,
FIR was
I will
filed.
not go into the merits.
There is
Abatement to suicide.
Someone told it. Lordship, Lordship, kindly, your lordship.
There are other urgent matters to
All
attend
the-
to. Boys
all
have
the-
exams.
Lordship, all the accused persons have
One
got bail
67-year-old lady. There are other as good as your as urgent as your matter.
Lordship,
No,
the other
I
accused
won't be
persons
able
have
to.
been
I
given-
won't be able to cope up. I'm also a human being. Come on.
Deep level lecture.
No. AB not tomorrow. See, just behind bars, she was requesting me honestly. No way. 26 March. But AB, you are not behind bars.
My bail application, Lordship. Lordship for calling of record, Lordship. Because Lordship has passed the order of the co-accused. That is why it is listed. It has to be listed before your Lordship. So can it be this week? Can it be, Lordship?
Not this week.
For LCR, Lordship. Nothing.
No, LCR, not this week. I'm really sorry. Very, very extremely sorry. Not this week. 26th.
If automatically come, then that will be okay, Lordship.
You automatically how it will come? Let me
Because
know.
already once
Tell me.
listed, no, Lordship, already listed and the direction was passed to list before dishonorable court, Lordship. By the other court, Lordship.
It's automatic, I don't know, but I'm giving you a date.
Lordship. Obliged.
For listing of two criminal petitions, the problem is one husband, he had two wives, both filed maintenance cases. Awards have been given against them. They have filed, husband has filed revision against both wives, and there's a stay. So any date plus one prayer that both may be listed on the same day because he's not paying maintenance there, and warrant is also
Next week.
any
or
date,
no?
ma'am.
28th March.
Deep noted.
Both the list, both can be
Both cases.
listed.
May it please your lordship, I would like to mention item number 9, your lordship. It was called for police report, but I think yet the police report has not arrived.
Report as called for is not received. We should reminder list the matter on. You'll be able to bring on 28th.
Obliged.
Item 1, 2, and 3.
Item 1, 2, 3 look at the motion item might not have any city receipt.
No, not motion item, Lordship. Wrongly listed as motion.
That may be.
Wrongly, it is a bail hearing matter, Lordship. Case diary was called for, Lordship. Injury report, it was supposed to.
After some time, come on, after some time. Under which sections?
Other sections are, Lordship, 118, 3294, 3244, 118, 35, Lordship. Only that section is.
118,
Lordship.
previous cert. One is AB, the others are BA,
Lordship.
previous injury.
As per the.
So,
section.
we'll need the injury report. Where was the injury caused?
Lordship, Bhangar, Lordship.
Huh? No. Where, on which part of the body was the
It
injury
says
caused?
head, Lordship, as per the.
On his
FIR.
head.
Lordship.
Where is the FIR? Let me see.
FIR, Lordship, will find on page 10, Lordship.
You are behind bars for how many days?
Lordship. Yeah, I said on 4-3, Lordship.
4-3, okay.
This person got interim, Lordship, and the rest of the two are arrested on, Lordship. 4-2, Lordship. 43 days, Lordship. There are cross FIRs also there, Lordship, between two family neighbors, Lordship. That part of.
Okay, we'll need the injury report. Injury report, injury report is not forwarded along with the CD. Send back the CD, call for the up-to-date CD along with the injury report, list the matter on 26th of March.
Much obliged, Your Lord.
May please remember. LCR may be called for your.
NDBS,
No, Lordship, 302 year.
302. Call for the LCR, this is, charge sheet has been submitted.
Yes, Lordship, trial is.
Call for a scan copies of the trial court records along with the scan copies of the CD, list the matter on.
Can it be after April, in the month of April? April.
Item 5.
May I, the Lordship, he is behind the bar, 3 days for the Lordship, and FIR is page 8, Lordship, there is not direct allegation against the petitioner. Petitioner is 60 years. 60
Who
years.
is the FIR page?
FIR is page 8, Lordship. Finally,
Who is the petitioner here?
petitioner is Lordship.
Moina
Mia
Mia.
Lashkar. Lordship.
FIR is at page 8.
8, Lordship.
Please read.
The humble statement is that there is a pending land dispute with the FIR named accused person. Often the accused person threatened me and my family members of dire consequences. Accordingly, due to the affair on so a case under section 126 BNSS against the accused person was filed. Thereafter, on so at about other, the accused persons assaulted my brother, namely friends, causing grievous injuries on his person, and in this regard, on an FIR to the Hailandi police station against the accused persons, which is under investigation. Due to lodging of the said FIR, the accused persons became more aggressive, and on 15/11/2024, this is the new lawsuit. All the accused persons in pre-planned manner with the intention to kill, armed with thou, danger, etc., were sitting under the petty tree, and at about 4 p.m. while my niece, namely Ajmal Hussain, Lashkar, aged 88 years, was on the way to cut the grass.
Okay, let us call for the CD.
But only Lordship petitioner accused number 1 and 2 is.
Yes, let us call for the CD. Call for the CD, list the matter on 28 March.
Item 6.
May it please your lordship. And that the accused is behind the bar on your lordship on 3/2/2025, your lordship. Prima facie, there is no case. Your lordship, page number 20 may kindly be looked, page number 10 may kindly be looked into, your lordship. Because your lordship, 2 boys they booked a room, your lordship, along with a girl, your lordship. So your lordship, and accordingly, your lordship, an allegation has been brought, your lordship, that the girl is because of her poverty, your lordship. So he has been, your lordship, committed rape. Totally false allegation. Had there been any, your lordship, physical?
It's a case of rape.
It's a your.
Direct allegation of rape.
No, lordship. Ye BNS 143(2) BNS. 143(2) BNS. So had it been, if such incident had happened, your lordship, certainly the girl, she's a young girl, your lordship, attained the age of majority, your lordship, she could have filed a law's affair or her family member, your lordship. I am already 42 days behind the bar, your lordship. Totally false allegation. It is because of the fact that they booked the room in the hotel. Therefore, in order to save the hotel man from any such kind of, your lordship, therefore this affair has been lost.
Yes. PP.
143 trafficking, your lordship.
How old is that girl?
40. She's 25 years above, your lordship. So 43 days already.
What is the punishment? Highest punishment?
Highest punishment, your lordship. Extend to 10 years, your lordship. But your lordship.
You are behind bars for how many days?
43 days, your lordship, as on date, your lordship. 43 days, your lordship. No case at all, your lordship.
You want the CD?
Lordship, here in this case, your lordship, had the incident been happened, your lordship, suddenly the above 25 years, 43 days, your lordship, as of no case be against the primary, no case at all, your lordship. So, kindly.
You want a CD? Just a moment. Let me go to the FIR once more.
Lordship, FIR may kindly go. May I read the FIR, your lordship?
Once more.
May I read the FIR?
Yes, please read.
Lordship, I would like to inform you that I am working as manager of Hotel Aditya Palace, phase 10, your lordship, palace located
Just a moment. Please don't repeatedly submit that he is not at fault. He may be at fault. I can grant you bail. Please read the CD. He may be at fault. I can grant you bail even if he is at fault. Please don't submit that he is not innocent. Please read the CD.
Actually, he is the driver, you know. Actually, my petitioner is the driver.
Hmm.
So he accompanied only
No,
another.
I do not want those stories. Please read the CD.
Lordship. FIR, Your Lordship.
Yeah, oh, sorry.
Located
FIR.
at Last Gate, Dispur on 1/2/2025, two boys approached me at my hotel and asked for booking a double bedroom. Accordingly, room number 102 has been booked for them. During the stay, on checking the CCTV footage, it is found that the two boys brought one girl and another three boys kept them in the room last night. On thorough inquiry, it is revealed that they brought a girl promising her to provide a job, and taking the advantage of her poverty, they forced her to sex with them. Their intention was to traffic the girl for sex labor. After knowing the fact, immediately we informed Dispur police. Accordingly,
Short date. Only 1 week's date. Call for the CD, list the matter on only 1 week's date.
26 you lost it, man. Maybe because at Dispur you lost it. Here is Dispur, short date. Because already
24.
Do-
May I please your lordship? Lordship, this is a matter in connection to Dispur PS. The allegations were made.
103.
Yes.
Call for the CD, list the matter on 28 of March.
Much obliged.
Item 8.
Maybe the connected matter is fixed on 20. Lordship.
Call for the CD, list the matter on 20 March.
Much obliged, Your Lordship. Much obliged. Okay, very good.
Item number 11.
Order dated 13/9/2023, as per a Thanet additional CGM, at Gaurahat Mohalda has been put to challenge in this petition. Lordship. What happened? The respondent number 2 has filed an application under section 12 of the DV Act, seeking
Of
some
the DV Act. okay.
DV Act, seeking some relief against me, Lordship. Lordship, accordingly, the learned court below issued notice, but that notice was not in consonance with the law laid down in the statute, Lordship. Section 13, kindly have a look, Lordship. Section 13 is very clear.
DV Act on the other? Yes.
Lordship.
Just a moment. DV Act, this is a criminal petition against an order of DV Act. So you'll have to file an appeal under section 29.
Lordship, that part, Lordship, kindly have a look to paragraph.
You have already filed an appeal before the district judge.
No, Lordship, kindly have a look at paragraph 5, Lordship.
Paragraph 5.
The reason I have stated, Lordship.
Please read.
The petitioner begs to state and submit that he ought to have filed a statutory appeal under section 29 of the Act of 2005, assigning the order dated 13/9/23, passed by a Lionel court below. But as his youngest counsel is having CKD ailment and presently under dialysis, as such, it's become difficult on the part of the youngest counsel to visit the courts at Mongol, Lordship, for his physical condition. As such, under these peculiar circumstances, the petitioner has invoked the inherent jurisdiction of this honorable court.
482.
I am suffering from some ailment, Lordship. So, under these peculiar circumstances, this present petition has been filed, Lordship.
Who is suffering from kidney?
I-
You are suffering. What is your ailment? Kidney stone or
Congenital ureter stricture was there by birth, Lordship. So my urine was not passed properly. So I suffered hydronephrosis. So accordingly, creatinine level was raised. So under this peculiar circumstances, I have approached the court. So my
I don't know. I haven't come across such a petition in my life.
clinical petition, Lordship.
Yes.
Assailing the order that assailing the order passed by the Planet Trial Court in DV proceeding.
Yeah, because erroneously they submit, but knowingly nobody prefers a revision. Erroneously, many revision petitions have been preferred, but you have preferred it knowingly. So this is the first time I have come across such a
Under these
situation.
peculiar circumstances, Lordship, I have
Yes.
stated in my petition. So this honorable court may proceed for the interest of justice. Inherent power of the High Court cannot be curtailed under any condition. In my humble submission.
We'll issue notice.
Lordship, before Issuing notice may submit notice.
No, see, we'll issue notice. That much I can do, but
Lordship,
more than that I
In
cannot
my
do.
humble submission, Lordship, the consideration of the interim prayer may be kept open. Lordship.
Sorry,
The consideration of the interim prayer may be kept open in the subsequent stage.
sorry.
The consideration of the interim prayer, Lordship,
Ah.
I'm staying for the staying of the operation of the order,
Ah.
that may be kept open, Lordship.
Yes, of course. You have filed this under, please help me, PP also help me out later.
520.
Keep this in mind, help me out. Under 482 as well as
As well as Lordship, 482, 227.
528 is 482
482, Lordship.
and 227. Okay. I'll have to ponder over it. Okay. Hard learned counsel, Mr.
GRA Muttaq.
GRA Muttaq, learned counsel for the petitioner, comma, and learned additional PP Assam for the, you have added him as a party, no?
Lordship.
Respondent number for the respondent state, likhi diya. For the respondent state, petitioner to take steps to issue notice to the respondent number 2 through registered post or usual process.
Registered post.
Through registered post with AD as well as through usual process returnable returnable on data media. Meanwhile, call for the scan copies of the trial court records.
Lordship,
Okay, the prayer for stay of the operation of the impugned judgment and order dated
13/9/23.
in connection with
Into a mixed litigation number 23, Lordship. 24 of it, 23.
Likhila number will be considered on the returnable date.
Much of.
May I please, this matter may be passable for 10 minutes.
Maybe. This matter relates to quashing of FIR regarding POCSO case. The petitioner and the opposite party no number 3 is there.
Will issue notice?
My lord, kindly stay the proceeding, my lord, otherwise he will be arrested, my lord.
Sorry?
Kindly stay the proceeding, issue notice, my lord.
No.
My
We
lord-
have to issue notice.
My lord-
POSCO case.
My lord, in various high court, my lord, including your lordship, my lord, has quashed the petition.
Can quash. I'll also quash.
Your lordship.
But now we'll have to issue notice.
My lord, this is a non-bailable offence. If the petitioner next date is 24/3, my lord, accordingly, an inviolable warrant of arrest executed, my lord. So it will ultimately hamper, my lord. So kindly, as it is a case of clear-cut case of quashing, my lord, in various high court, including the Supreme Court.
Notification कौन सा कैसे देखो सर? Notification कौन? Is a POSCO notification कौन?
My lord, Rajasthan High Court also passed and they state against the order filed SLP in Supreme Court, my lord, and SLP also, the Supreme Court also dismissed the case. These are.
What is your urgency?
Address, my lord, next date is 24/3/2025, my lord.
Yes.
And as the case is non-bailable offence, my lord, if he is not appeared, my lord, he say appeared, my lord, he has been put behind the bar, my lord. And otherwise, he is not appeared, my lord, non-bailable warrant is.
You are praying for bail?
No, my lord. Or just stay the further proceeding may be extended.
Why are you apprehending arrest? You haven't appeared before the court.
No, my lord, I have not appeared because this section is non-bailable, my lord. If I have.
You are shown as absconder or what is your story?
No absconder, my lord. Just notice has been issued, my lord. I have an copy, my lord.
Notice has been issued to you.
So if as per notice, my lord, if I appear.
Then why you are not praying for bail?
My lord, as the case is clear-cut case, my lord. The various high court, including the Supreme Court, my lord, kindly see the Supreme Court order, my lord. The state of Rajasthan versus Tarun Vaishnav, my lord. The Rajasthan High Court was the petition, my lord, was the affair, my lord. And against that order, my lord, the state of Rajasthan filed SLP against Supreme Court, my lord. And Supreme Court also dismissed the appeal, my lord.
Here, my lord. And there is a page 33 of the petition, my lord. It's ordered at 29 2020. Now, my lord, here the there are my lord, three numbers of petitioner, Chandra Das, Nitin Das, and my lord, the order states that IO has forwarded certificate after completion of investigation under Act read with section 617 of Foxtel against accused person namely Atik Chandra Das, petitioner number 1, Nathuram Das and Nitin Das. Nitin Das is petitioner number 2, my lord. The showing all the accused person as a contract. My lord, certificate submitted showing them as a accused person. Now, my lord, after the Foxnax case, my lord, the notification is if there is a case, my lord, related to Foxtel and all. That is my answer.
But both the parties were heard in this case.
My lord,
In the Rajasthan High Court case, both the parties were heard.
lordship, my lord, they are but my problem is that, my lord, if I am appeared, my lord, the petitioner may be.
You cannot rely on this case. You cannot rely on this.
And other, your lordship order and Meghalaya High Court order is also there, my lord. Yes, it to the. My problem is that, my lord, if I am appeared, my lord, I may be arrested, my lord. As they are living together as husband and wife, my lord. And one petitioner and one person has already
No, but
died.
here notices have been served. I have been served here. My order, I have passed no order
Lordship,
only after
Lordship,
notices were served.
Lordship, my only thing is that, my lord, only problem is that, my lord, if he is not appear on 24/3, my lord, non-available of warrant, and again he is appeared, my lord, he put behind the bar.
Here also notices have been served. Your cases are not helpful here. Later stage we can take it up, these cases, but these cases are not helpful here. You give me any example where notices have not been served, where notices have not been issued, and thereafter a stay order has been passed ex parte without hearing the respondent number 2. You give me example, then I'll follow suit. There's no example here. Both the parties have been heard.
Man, what will be given, my lord?
Yeah. Of course, short date will be given.
Before 24, my lord. Otherwise, it will hamper, my lord.
Before 24, today is 17. Another 7 days. Maybe you may get a relief. Third learned counsel,
S.
Mr.
Rahman.
S.
S. Rahman.
What?
S. Rahman.
S. Rahman for the petitioner, former learned additional PP. Mr. K. Bosher for the respondent state. Petitioner to take steps to issue notice to the respondent number 2 to the office of the PP.
My lord.
Returnable on the heading Sobisa Agot video. Meanwhile, call for the charge sheet has been submitted. No, call for the scan copies of the trial court record along with the scan copies of the CD.
Highly obliged.
List accordingly.
Highly obliged.
May I please, Your Lord? So basically, also this petitioner is aggrieved by the inaction of the Lord's trial court. Although this petitioner in the trial court filed a complaint case regarding against this respondent number 2 and 3, stating that she is the wife of respondent number 1. Respondent number 1. She is the wife of respondent number 1.
Just a moment. A notification grad
Yes, all her children articles she left at the house of her respondent number 1 and 2. So accordingly, to recover those articles, she preferred in a criminal complaint case before the London trial court, and it was filed in September 2024. Although the notice was served thrice, and notice has also been duly served, as the postal report says, but the London trial court has not issued any order to recover those articles. Only again issued fresh order that you will find at page 41. The last order.
This is the order you are agreeing.
Lordship, basically, I am agree with the inaction on the part of trial court to issue any search warrant to recover her children article.
Page 47.
Page 41, Lordship. Page 41 is The first order, Lordship. It was on 21st of September 24. The complainant issued notice upon the accused in order to provide an opportunity being heard as provisions under section 223(1) of BNSA. Accordingly, we have Lordship, steps were taken by this petitioner and notice was issued to this respondent. On the next date also, Lordship, same order, although we have, Lordship, humbly prayed first to issue a search warrant so that we can recover the articles because this respondent was threatening to set fire all her student articles. Accordingly, we have also lost FIR against them. That FIR is still pending. They have even, Lordship, intrude in the house of this petitioner at Guwahati and broken his gate and all. Now they are threatening to set fire all the student articles. Despite, Lordship, those incidents, the learned trial court has refrained it first any order to issue search warrant to recover this student article, Lordship. Next, third order, Lordship, in final page 42, the last order. Page 42, Lordship, complainant is present, accused is absent. Notice to accused return to the sender with a report, perhaps, Lordship, report. Complainant to take fresh steps in a proper address. Fixed. It was initially it was fixed on 20 of February 25. But subsequently, Lordship, we have again submitted the postal tracking report. That notice was duly served. We have submitted the postal tracking report. Despite, Lordship, submitting those postal tracking report, the learned trial court has refrained to, Lordship, pass any search warrant. So now, Lordship, the apprehension of this petitioner is there. Since the, Lordship, she left the house of her matrimonial house, they are threatening to set fire all her student articles. There is every apprehension that, Lordship, they will misappropriate or, Lordship, misuse those articles, and these are very much necessary to recover this article. So at this humble prayer, I am not
Who is
seeing
the
any
complaint petition?
complaint petition, yes, Lordship. Complaint petition starting from page, Lordship, it was 24, Lordship. And list of articles, Lordship, will find starting from page 34, Lordship, list of articles that she has left in her matrimonial house.
So what is your prayer?
Only prayer is to, Lordship, let the trial be proceeded, Lordship. Our only student articles may be recovered, or direction may be given to recover his student articles with the help of, Lordship, concerned police station. That much, Lordship. I am not seeking any other than.
I can give a direction only.
Lordship.
What is your ground in the petition? Prayer I have seen.
Lost. Grounds, but only 3 grounds I have, Lordship, put in the petition, starting from page 14. Page 14, ground number 2 and 3, Lordship. Basic grounds is that, Lordship, inaction on the part of trial court. Despite, Lordship, service being notice being served duly, as stated by the postal tracking report. So again, Lordship, it is issued fresh summon.
Ground number 2 and 3.
Lordship.
Mr. J. Kolita. Okay, then I'll just direct them to pass a necessary order for as they are apprehending that the articles will be damaged. Mr. J. Kolita, learned counsel for the petitioner. नाम तो लिखे बना देते हैं family case. Petitioner X, who has filed his application under section 482 of the BNWS 2023, read with Article 227 of the Constitution of India, seeking interference of this court in the proceeding of CR case number 609 of 2024, pending in the court of the Judicial Magistrate First Class, Kamrup Metro, at Guwahati, within bracket, magistrate for short bracket closed. Magistrate or trial court for short, magistrate or trial. Third learned petitioner PP Assam, Mr. K. Bosher, for the respondent number 3, within bracket state of Assam bracket close. Full stop. This case was brought up by the petitioner against the respondents number 1 and 2. Full stop. The respondent number 1 is the petitioner's husband, and the respondent number 2 is her mother-in-law. Full stop. The case was registered under section 316 of the BNS 2023, a single SD, BNS 2023. Basically for recovering of the student articles of the petitioner. Full stop. The petitioner has been threatened by her husband and her in-laws. Next, the petitioner has been threatened by her husband and her in-laws that they will, husband and her mother-in-law, by her husband and her mother-in-law, that they will set ablaze all her student articles which are in their custody. Full stop. It is submitted that the petitioner is at present residing in her parental home and her student articles are in her in-laws' house. To stop. There are many valuable student articles and the list of the student articles is marked as annexure.
Annexure 2 is the complaint petition.
Is marked as annexure 2 of the petition. To stop. Cognizance was taken against the respondents, but no order was passed on which was the order?
Last is 21/9/24, 2011/24, and last is 5th of February 25. At page number last is 41-42.
Forty-one and 42.
Lot.
But no order, 40, 41 and 41, but no order was passed on 21/9/2024 onwards. Onwards.
Lot or not.
For recovery of her student articles, or no such warrant was issued to identify and recover the student articles of the petitioner lying in the respondent's house. It is further submitted that the petitioner submitted all the documents pertaining to purchase of the student articles, but the learned trial court has ignored those documents and a date was fixed after more than 2.5 months for service of notice on the respondents. Full stop. Respondent number 1 and 2. Respondent number 1 and 2. The petitioner who is the petitioner is hesitant to get her articles recovered from her student articles recovered from her matrimonial home without the aid of police, as she is apprehending resistance by her in-laws. As per Alika, I have considered the submissions at the bar. The petitioner has prayed for recovery of her student articles. The petitioner has brought up this case again. The petitioner has brought up this case against the respondents solely for recovery of her student articles. It is apparent that the prima facie case was found and thus cognizance was taken by the learned magistrate. The magistrate is therefore directed to pass necessary orders for identification and recovery of the student articles. Identification and recovery of our student articles in accordance with law.
I think in accordance with law, Lordship, again, Lordship, they may issue again someone or Lordship. Lordship may direct the trial court, Lordship, to pass an order.
Yeah, I have
at least
redirected.
to recover this with the help of Lordship, the concerned police station. That much, Lordship.
In accordance with law, it will imply that the police is directed.
Then Lordship, a fixed time period, Lordship. Then it will, I think
Within
10 days or 1 week, Lordship, that it will work.
time period.
One
That
week,
day you were present in this meeting, no?
Yes,
The
Lordship.
time frame
Lordship,
should not be
I was there,
given.
Lordship.
And there is a judgment also.
Lordship, I have also considered judgment. Lordship, only problem is that Lordship, if as per law is directed, Lordship, then see that Lane trial court would again, Lordship, issue.
As early as possible. As early as possible.
Lordship.
As early as possible and in accordance with law.
Lordship.
In terms of the above observation, this petition stands disposed of.
Lordship. Obliged. Item 19, item 12.
May I please? Lordship, the impugned order is at page 92. This is an order whereby the prayer for defreezing of the accounts was rejected. The petitioner's account was rejected. The fact of the case is that initially there was an FIR against the father of the petitioner number 1.
I have dealt with this case. I remember. Earlier, I don't know, I have given a notice or something. I don't know. I don't remember. Actually, there's a bail or some orders have been passed. I have dealt with this case.
Initially, order was passed. So, director search sheet, in the meantime, search sheet has been filed. So, bank statement was taken into account in the search sheet. Thereafter, we are directed to move the court below by this honorable court that there is an order that is at page, it starts from the order, it starts from page 70 and the operative portion is at
I have passed this order, no?
probably Lordship. Your
Okay,
Lordship.
okay. Mitali Thakur has
Yes.
passed this order.
Then we have approached the court below and what they have passed.
Maybe I have passed some initial order, I think.
Yes, Lordship, probably your Lordship has passed on initial order in this case. So now it has again come because the trial court has rejected my prayer, saying that the link, there is a link, so it may be necessary, so this has been rejected.
So we'll consider a stay after we receive the LCR.
Yes, Lordship.
Our learned counsel, Mr. S. N. Tamuli.
Yes.
For the petitioners, mother and daughter, no?
Yes.
I remember mother and daughter.
That time only mother has approached, now daughter has also. Because her
No. Daughter had also approached. Maybe
she was not a petitioner, but her accounts were also taken into consideration.
Oh,
that time.
yes. For the petitioners, Ms. Pooja Bora and Srimati Bonali Dr. Bora, and learned additional PP Assam, Mr. K. Bosho for the respondent number 1, petitioner, full stop, petitioner to take steps to issue notice to the respondent number 2 and 3 to register post with AD as well as to issue process returnable within 4 weeks, or you want a date?
Yeah, Lordship is sorted. Banks are
Returnable on 9th April. Meanwhile, call for the scan copies of the trial court record along with the scan copies of the CD. This is a criminal case, no?
Yes, Lord.
Along with the scan copies of the CD. The prayer for interim stay will be considered on the returnable date.
Wait, Your Lord. But in this case, Lord, the honor of his check, Miller, a criminal complaint under section 138 of the negotiable was filed, Lord. Thereafter, the learned trial court granted an interim compensation of 50 lakhs. We are challenging the order taking cognizance as well as the interim compensation granted, Lord. Milord, may kindly take a page 34 for a moment. Page 34, Milord. This is the check, Milord. 13/7/2019 dated, Lord. Milord.
Interim compensation
Interim compensation has been
under
granted.
section 482.
140. We are under
No,
442.
this petition is under
Yes, under
482 because no revision will lie against interim compensation.
Lordship. We have prepared revision to the section for advice dismissal. We'll come to that, Lord. 13/7/2019, Milord, is there. Then Lordship will see the next Milord take return memo, Milord.
Next,
Page 35, Milord.
you want a interim stay?
Interim stay of the order, Milord. That is 22/11/2020.
Let me see the order first.
Milord. Page 42 is the order, Milord. My case is, Milord, the notice was not issued within the stipulated period, Milord. In that background also, this order could not have been passed, Milord. Page 42 is the order, Milord. And the relevant portion is page 43.
Please read the order.
Lord. Complainant is represented by learned counsel, accused absent by steps. Today was the date fixed for necessary order in petition number so and so and cross-examination of PW1. By petition number so and so, the complainant prayed for granting interim compensation under the provision of section 143A of the NI Act. Heard both sides petition on the earlier date. The contention of the complainant is that in the year 2019, after appearance of the accused, the case was sent for mediation to DLSA in Sukia, but due to the reluctant attitude of the accused, the matter could not be settled there. Complainant has been facing financial difficulty due to non-payment of accused amount of rupees 19,96,081 by the accused. Defense submitted that the defense contention is total denial of this case. Even the ground of dishonesty as reflected in the complaint is drawn signature default. As such, he prays for rejection of the petition of the complainant. Now, in the instance, the alleged check amount is so and so. Honorable Supreme Court in so and so has held that even dishonor of check on ground like draw signature differs from specimen supplied. No image font, signature and incomplete, so it will be taken into account. And this is very relevant. Under section 143 of the NI, the court may order drawer of the check to pay interim compensation to the complainant where the accused pleads not guilty to the accusation made in the complaint where the proceeding goes as per a summary procedure or summon procedure, and in any other case upon framing of charge. Now, in the instance case, check amount is quite high, the so and so has been allowed. Recently, Lordship, in 2024, one judgment was passed by the Supreme Court where they have laid down that what are the formalities that were to be required before passing an interim compensation. The copy of the judgment we have given, Lordship, in Rakesh Ranjan Srivastava case. So that has not been complied with. One. Second is, if your Lordship takes up page 35 for a moment, we are coming to the judgment.
Page 35.
Page 35.
Yes, page 35.
The check date is 16 July 2019. This was the date on which the check was presented. And return date is 17/7/2019. And notice has been said, this is page 38, Milord. Return date 17/7/2019 check return memo. And page 38 is the Milord notice sent, Milord. It is sent on 16/9/2019 after more than 2 months, Milord. So the statutory bar of 30 days. But
notice was sent, no?
Notice was sent, but not within 30 days, Milord. 138 which says 30 days, Milord. So prima facie, Milord, they don't have a case, Milord. And that is what has been held by the judgment, Milord, Rakesh Ranjan Srivastava case, Milord, that the court has to see whether this judgment that we have. First paragraph, if you may kindly see. The issue involved in the criminal appeal is whether the provision of
Where, which first paragraph?
of the judgment, Milord, that we have submitted. Rakesh Ranjan
Okay,
Srivastava.
yes.
May I read,
Yes.
Milord? The issue involved in the criminal appeal is whether the provision of subsection 1 of section 143A of the Negotiable Instrument Act, which provides for grant of interim compensation, is directory or mandatory. if it is held to be directly prohibited, the question that arises is what are the factors to be considered while exercising power under subsection 1 of section 143 of the NIA? Now, Lordship, can we take up page number 17, my lord?
Page 17 of,
Page of this judgment. Lord.
yes,
Subpara C of 19, my lord.
Para?
Subpara C, my lord, paragraph 19, subparagraph C. Page
Okay.
17.
Para C, yes.
Para C. The broad parameters for exercising the discretion under 143 are as follows. The court will have to prima facie evaluate the merit of the case made out by the complainant and the merit of the defense pleaded by the accused in the reply to the application. The financial distress of the accused can also be a consideration. A direction to pay interim can be issued only if the complainant makes out a prima facie case. So, my lord, I am saying that order dated 25 to be a state for this and lordship.
Order dated 20?
25 to 2022 passed by the trial court granting interim compensation be a state. That action was there. Lordship can quash it and send it back to the trial court for fresh consideration in view of the judgment also. Order only to the 25/11/2023. But the judgment is very
Yes, I'll have to hear the PP.
PP will not be the only formal party, my lord, because
No, any submission you have to make? No. Okay, all right. Have you annexed any reply? Notice?
no, my lord.
Reply of notice?
No, my lord.
Why the delay of 2 months? Anything relating to delay and of 2 months?
No, they said that they were not present here, my lord. At Tinsukia, that is why the delay. But it has to go by the check return memo, my lord. And whatever it is only for interim compensation that we are praying for, my lord, they have to make out a prima
I'll dispose it altogether, but not today. I won't grant stay today.
Look, stay has been, but that it is on 21, Lord. So
I'll
order
just
that
call for the records. If it comes on the same day, I'll dispose it.
Lord, may kindly, my lord, you should notice, my lord, and order dated 22, 25/11/22 we
No, see, he's facing hardship, and in this judgment itself, if the person is facing hardship, he can apply for interim.
judgment for is for the accused is
And he has
facing
also given something in reply that they were not there. So without stay, I'll dispose it on the same day itself.
Lord,
Let the orders
the
records come.
trial will is on the next it is on 21, my lord, and it is fixed for the cross-examination of the complainant.
Let the complainant be cross-examined. There's no harm.
Lordship,
We'll call for the
But if the order is not
same day, I'll dispose it. It's not a very difficult, tough matter. I'll dispose it. We'll hear both sides and dispose it. Heard Mr. A. Lal, learned counsel for the petitioner, and Mr. K. Busher, learned additional PP for the respondent state. Petitioner to take steps to issue notice to the respondents. Number 1 or 2.
1, 2, my lord.
Respondent number 2 to register post with the AD as well as to legal process returnable on data detail. 10th of April, is it okay? 10th of April. Also call for the scan copies of the trial court record. List accordingly.
Lordship, no coercive action till then, my lord, by the way.
No,
there is a coercive
no,
action.
no,
my lord.
We'll dispose it. Or else we can give you an earlier date. Earlier date I can give you.
Well, only in the coercive action, we are not even praying for a stay, my lord. They should not pass any coercive action against me, my lord.
No coercive action will be passed. You can give a copy of this order.
We'll submit, my lord.
On
But
that
then
day?
also, if the order is explicit, my lord,
No coercive action in NI matter what. There is no execution proceeding in NI matter.
Item 16.
of later.
May I please?
My lord, I am convicted under section 138 of the NI Act by the learned trial court. I have filed appeal, lordship. In the appeal, the appellate court has passed an order directing me
Pay
to deposit 20%.
25%.
Okay. But lordship, my case falls under exceptional category, lordship. Because lordship may kindly see, lordship may kindly come to page 15, lordship. The complaint.
If you're praying for state, and we'll have to hear you, and if I can fix it for LCR, then we'll consider after the LCR.
Then the proceeding may be stayed till then, lordship.
What
Otherwise,
kind of
lordship,
proceeding? Judgment has been passed.
Judgment passed, but I am directed to pay 20%.
Within how many days?
Lordship, within 60 days.
20% of the amount.
Within
within-
60 days.
So from today counting?
So 16 already gone. Thereby, thereafter 30 days extended, and today is the last day. Today the appeal is fixed before the learned court. My case falls under the exceptional category, lordship.
Then we'll hear it and dispose it of that.
And lordship may stay till then, lordship.
No.
Otherwise, I have to pay
No, we'll hear
20%.
today itself and dispose it of. If you are thinking that there is a ex parte stay which is required, then we'll hear it and dispose it
Lordship,
of.
otherwise, the issue will become infractious, lordship. 20%, lordship. I am against 20%. Therefore, I am before your lordship. This is exceptional. Lordship may kindly see.
How much? 20% of how much?
20% of 9 lakhs, lordship.
How much will be 20% of 9?
It will be 1,80,000. 1,80,000.
And how much did you borrow?
7
You did not
lakh.
borrow.
Check amount is 7,50,000, lordship. The complainant, neither the complainant knows the present petitioner lordship, nor the present petitioner knows the complainant lordship. The check was issued to somebody else. Petitioner borrowed some money from somebody else. His name was also there, Anwar Hussain. And
No, I will
check
not go into the merits of the
lordship.
case.
Lordship, then lordship may finally dispose of it. Till then, the order may be stayed, lordship. Of course, this is an exceptional case, lordship. And in this regard, I am also relying on some Supreme Court judgment.
Why should I hear the entire merits of the case? Only one ground where you could not, you are denying the issuance of check. Have you denied it?
Yes,
in the
yes, sir.
court?
Completely I have denied, lordship. Because we didn't have no any relation.
All right, then you can start from the complaint, then from the notice, reply on the notice, and then evidence.
Lordship.
Not on the petition alone.
Lordship is finally hearing.
No, not. I'll have to hear both sides
Lordship,
to
lordship,
dispose
both
of
sides.
this case.
Yes,
not,
lordship.
So, you have annexed the copies of the complaint.
Yes, lordship.
Then
Page
evidence.
15. Evidence also annexed, lordship.
Then you have annexed the copies of the notice.
Notice.
Reply on the notice.
Yes, yes, lord.
Then start from the notice, reply on the notice, and everything. Complaint, petition, everything.
Yes, lord.
And the judgment.
Yes, lord.
So no evidence not required. In the judgment, we'll find the evidence. You'll have to read now.
Yes, lord.
You can start from the complaint petition.
Yes, lord. Page 15 is the complaint, lord.
Yes, I'm at page 15. Read. Please read. You'll have
Yes,
to read
yes.
it.
Para 1, lordship. That both the complainant and the accused are the permanent resident of the above noted location within the jurisdiction of this honorable court, and by profession the complainant is a businessman specially dealing with treasury. On the other hand, the accused is a subject teacher of so-and-so school. That the complainant and the accused person are the near villagers and hence known each other very well and having a friendly relation. Lordship, kindly take note of these two paragraphs, lordship. It will bear something to his evidence, lordship. That on 9/3/2018, the accused person came to the house of the complainant and requested the complainant for an amount of rupees 7,50,000 only as temporary loan for his urgent necessity, and hence due friendly relation, the complainant on the same day gave the amount of rupees 7,50,000 only in cash to the accused person, and by receiving the said amount, the accused person gave commitment to the complainant to repay the said within 2 months from the date of receiving the money or as demanded by the complainant. After 2 months, as the accused person had not paid the money and committed to the complainant, as such the complainant requested the accused person for several times over telephone and also went to the residence of the accused and requested him to return the said money. But the accused person replied at that time the said amount was not available with him as he has been facing severe financial problem and told that he would definitely return the said money within a period of short time. That finally the accused person gave a check to the complainant on 26/4/2022 by check number so and so, amount so and so, only drawn on his account by AC number so and so, State Bank of India, Patsala branch. That after receiving the said check, the complainant on 25/22 presented the same in his account at the State Bank of India, Koikosi branch for collection and encashment of rupees 7,50,000 only. That the instrument was returned unpaid by the bank on the ground that sufficient fund and informed the complainant by check return memo number so and so. That complainant was shocked to learn about the dishonor of the aforesaid check on the ground insufficient fund, and complainant was under the belief that the check would be honored on presentation. That thereafter the complainant thought that through his engaged advocate sent pleader notice to the accused person in his correct address.
All right. Yes, I have read it.
Right.
So where is the reply of notice?
Yes.
Previous notice was sent.
Yes. Page 20, Lord.
Yes. Please read.
Yes. Under the instruction of my client, namely so and so address is that my client deposed to Anwar Hussain, son of so and so, address is so and so, to my client had given to my client rupees 4 lakh with 5% interest. The money was given to Anwar Hussain. That at the time of receipt of the aforesaid amount, Anwar Hussain have issued 3 numbers of blank checks, but your client Tapan Kumar Das, son of late so and so, claims rupees 7,50,000 bearing check number so and so, which was given to Anwar Hussain. My client and your client, namely Tapan Kumar Das, has no relation, not any transaction, and unknown.
So he has given how many blank checks?
Three
petitioner?
numbers of blank checks
Okay.
to Anwar Hussain.
No, I'm not staying. Not
Lordship,
staying.
Lordship may kindly see one more thing. Lordship may kindly see.
No, I'm
It-
not
it
staying.
is- it is a time bar check. Lordship may kindly see. Time bar.
Where is the check?
Yes, Lordship may kindly see from the plane itself. Lordship, the money was given on 9/3/2018.
Where is the check?
Lordship.
Page.
Page 15. Lordship.
No, check. Not the complaint.
It is reflected in the order also, Lordship. I am showing from the
Check number?
complaint itself. Yes, check number is there. Check number is 477081. Check I have not annexed, but it is reflected in the order of the learned trial court.
Yes, 477081. Yes.
Yes, Lordship.
Then date.
It was as per allegation, the money was given on 9/3/2018, Lordship, as per allegation, and the check was issued, Lordship. Lordship,
Where is the order page?
Praise Lord, yes, order Lordship, impugned judgment by the learned trial court at page 44, Lordship.
It's not mentioned that the check was
Yes,
issued on
everything is-
9/3.
Everything is there. Lordship, may kindly come to down below, 6-7 lines above, Lordship. Page 46, Lordship. Page 46. But the accused failed to repay the loan amount to the complainant as promised, and after repeated request of complainant, the accused issued the check.
No. That I'm not saying the date on the check is 26/4/2022,
Yes,
not
Lordship.
9/3.
And money was paid on 9/3/2018, Lordship.
Then only he issued a check.
Yes, because 4 years, he is bringing the allegation after 4 years. He says that I gave him money 4 years ago, 9/3/2018, and he issued me check on 26/4/2022, more than 4 years, Lordship. So it's a time bound, Lordship. And on that account, annual Lordship, it comes under exceptional category, Lordship.
Please read the judgment, why this argument was not taken into consideration.
It's a long judgment, Lordship. About 20 pages judgment, Lordship. May I read, Lordship?
No, only this part. You are saying that he borrowed the money in the year 2018.
Yes,
Then he check was issued.
on 22.
Yeah. So he several times he went to the complainant, and then he asked for time, and finally when the complainant was not allowed with the
This is
money,
his statement.
then he gave the check.
This is his
So,
statement.
no, I'm
Lordship,
not
may kindly
staying. I'm sorry,
see
I'm not staying.
TW1, the complainant's evidence, Lordship may say. He says he even does not know the complainant, present petitioner, Lordship.
Let the
This is
LCR
a-
come. I'll stay after the LCR.
Lordship,
Not
date
now.
is today, Lordship. Otherwise, I will be taken into custody, Lordship. Or NVW will be issued, Lordship. Today, the case is fixed.
No. Why NVW will be issued?
Lordship,
Oh, you have not. within
yes,
this
Lordship.
So you want stay now?
Yes, Lordship.
He is a student.
Today, the case is fixed, Lordship.
Then where did he get 7 lakhs then?
Lordship.
Why did he borrow 7 lakhs if he's a student?
I don't know why he is saying that he has borrowed from me. I don't know, Lordship. But
If-
because but his evidence
You are
by
saying that he has not borrowed, somebody else has borrowed the money.
yes with 4 lakhs. Somebody one Anwar Hussain borrowed 4 lakhs.
But in the check, it is written as 7 lakhs.
Say blank check was given as a
What is
security
the-
measure.
What is your relief? You take an order, you copy of this order and place it before the.
Lordship may kindly
You
stay,
can-
without stay.
No.
Without
You
stay,
don't,
stay,
please
Lordship,
don't
I will not be spared.
stay. You can take, I'll give you can take adjournment for 1 date. Don't insist on stay in it's
Lordship, this is
not justified.
after 60 days, 30 days was extended, and today is that 30 day, Lordship, last date, Lordship.
You
Lordship
cannot
is
take
aware that
adjournment also. You cannot take adjournment also. Judgment
no,
has already
Lordship,
been delivered.
because today is the last
Judgment
day.
has already been delivered, and then this is the first day of appeal in that-
NVW will be issued, Lordship.
in that appellate court.
Yes, Lordship,
No,
NVW will be
you
issued.
see, you're not listening to me. This is the problem why you're not listening to
Sorry,
me.
Lordship, sorry, Lordship.
You can take a adjournment for 1 day. Appeal is pending, isn't it?
Appeal
appeal
is
is pending.
pending, Lordship. Appeal is
Take
pending.
adjournment for 1 day. I'll pass an order for adjournment for 1 day.
Lordship,
I cannot go and stay in this manner.
Lordship.
Heard learned counsel Mr. M.I. Hussain for the petitioner, Sayesta Khan, and has submitted that the petitioner is a student and he'll be taken into custody if the order dated 4/1/2025
Yes, Lordship.
passed by the learned additional session judge Borpeta is not stayed. Because of the appellant was directed to pay 20% of the compensation amount of rupees 9 lakhs by the learned appellate court in appeal number 1 of 2025 within 6 months, within 60 days.
Yes.
Full stop. Thereafter, the appellant being a student had prayed for time, and the order was extended to 1 more month, allowing the appellant to deposit the deposit 20% of the compensation amount. The appellant has preferred an appeal as he has been aggrieved by the order dated by the judgment and order dated 5/12/2024 passed by the learned additional CJM Borpeta in NI case number 143 of 2022. The appellant can pray for adjournment for 1 day. Meanwhile, to consider the order of stay in connection with criminal appeal number 1 of 2025, the trial court records are called for full stop. Scan copies of the trial court records are called for. Meanwhile, the appellant is also directed to take steps to issue notice to the respondent number 1 to register post as well as to usual process returnable on date.
Fourth, it may be fourth. Lordship, may I say one more thing, Lordship, with humble request. Can I get the order
Today, yes.
during break hour, Lordship?
Huh?
During break hour, Lordship, I
Sure,
have to submit that order.
Yes.
Obliged, Lordship.
I'll come back after 5 minutes.
May I please, Your Lordship? Lordship, this is a 482 application of the anticipatory bail, Lordship. This is a Lordship cats and dogs fight between husband and wife, Lordship. Page number 14, Lordship, may kindly come to page number 14 in vernacular, Lordship.
Read it. Please read it.
In the year 2000, yes, Lordship. Hanman Hogare Apunak Jonause উল্লেখ কৰা আসামীয়ে আজিৰ পৰা 3 বছৰ আগৰ পৰাই এজাহাৰ কাহিনীক পত্নী হিচাপে গ্ৰহণ কৰাৰ প্ৰলোভন দি থাকি সম্পূৰ্ণ মিছা প্ৰতিশ্ৰুতি দি এজাহাৰ কাহিনীক মন ভাল লগাবৰ বাবে যোৱা ইংৰাজী 22/9/2022 তাৰিখে কুৱাখানা অন্তৰ্গত বাসুদেউ থানত পুৰোহিতৰ দ্বাৰা বিবাহ সম্পন্ন কৰে। It means, Lordship, marriage happened in Monday. Thereafter, Lordship, what happened? Next para, কিন্তু আসামীয়ে বিবাহ সম্পন্ন কৰাৰ পিছত এজাহাৰ কাহিনীক আসামীয়ে নিজ ঘৰলৈ নিনি এজাহাৰ কাহিনী ঘৰতে লগত শাৰীৰিক সম্পৰ্ক ৰক্ষা কৰি থাকি কোনো ধৰণৰ সন্ততি জন্ম দিব নোৱাৰাকৈ টেবলেট খুৱাই 3বাৰমান গৰ্ভজাত সন্তান নষ্ট কৰিছে। অন্য হাতেদি আসামীয়ে নিজৰ পত্নী বুলি চিনাকি দি থাকি এজাহাৰ কাহিনীৰ পৰা আঁতৰি থকাৰ চেষ্টা অব্যাহত ৰাখিছে। তাৰোপৰি আসামীয়ে আগন্তুক 3 মাহৰ ভিতৰত বিবাহ সম্পন্ন কৰিম বুলি মাজুলী জিলাৰ আদালতত নটাৰী কাৰ্যালয়ৰ সাক্ষীৰ সাক্ষাতত চুক্তি সম্পাদন কৰি চুক্তি পত্ৰত স্বাক্ষৰ কৰি ৰখা আছে ইংৰাজী 20/11/2024 তাৰিখে। কিন্তু পৰৱৰ্তী সময়ছোৱাত আসামীয়ে এজাহাৰ কাহিনীক নিজৰ পত্নীৰূপে গ্ৰহণ কৰা নাই। তাৰ বিপৰীতে এজাহাৰ কাহিনীৰ পৰা আঁতৰি থাকি ক্ৰমাগতভাৱে এজাহাৰ কাহিনীৰ পৰা ক্ৰমাগতভাৱে এই বিষয়ৰ পৰা এজাহাৰ কাহিনী আঁতৰ কৰিব বিচাৰিছে। This is the allegation, Lordship. What happened, Lordship? One bond was executed before notary public that within 3 months he will execute marriage. Due to some family problem, it could not happen. 3 months left, Lordship. I am praying for interim protection. Give me a chance. Because Lordship, already marriage completed before Monday. Lordship, now it is a part for social marriage. Lordship, give me a chance. Lordship, give me interim protection. I will appear and amicably we will settle the matter. Lordship. This is my humble submission.
Yes.
Yes, CD is required. I am not denying it.
If one is my not caused by
Lordship, may kindly call for the case diary. Yes, Lordship, call for the case diary, Lordship. Yes, serious allegation, Lordship. This is only what happened after it was happened after marriage before Monday. Now, lordship, only social part is not there. Social marriage part is not there. So lordship may kindly call for the case, they give me protection, give me a chance, lordship. If anything found against me, then lordship at the time of hearing it may be rejected, lordship. I have no objection then. Then I have no objection, lordship. CD will come after 2 weeks, lordship. Everything will be clear. At least I may be allowed to go to the police station to give my statement, lordship. And if there is such miscarriage, etc., there will be medical documents and it will be available in the CD after 2 weeks, lordship. If it is there, it may be rejected, lordship. Simple.
Okay then. Our learned counsel, Mr. G. Somwan.
Yes, lordship.
For the petitioner. Pranjal Parag, who has filed this application under section 482 of the BNSSS 2023 with prayer for pre-arrest bail as is apprehending arrest in connection with so-and-so PS case under so-and-so sections. Had Mr. K. Ghoshal, learned additional PP Assam. To stop the learned additional PP has raised serious objection against the prayer for interim bail. To stop the learned counsel for the petitioner has submitted that the allegation against the petitioner is that he has not socially solemnized his marriage with the
Informant.
victim, with the victim or with the informant stroke victim.
As per the
Full stop. It is however submitted that marriage was solemnized in the Dhokwa Khana within inverted commas Namghar, no? Khan.
Bakudev Khan.
In the Dhokwa Khana Bakudev Khan. In within inverted commas thereby, therefore, the learned counsel has submitted that marriage has already been solemnized and the petitioner cannot be held to be guilty of offense under section 69 and 81 of the BNS. The only part left the petitioner only part left. The petitioner is not denying his marriage to the victim.
Not denied. Only social marriage was not happened. And she is pressurizing that
The victim is, it is submitted that the victim is not satisfied with the marriage, with the solemnization of the marriage in the Than, and she is asking the petitioner
Social
to
marriage.
perform, to solemnize the marriage according to social rights.
Yes, yes.
And
Yes.
It appears that there are sufficient grounds to grant interim bail to the petitioner. Call for the CD list the matter on. In the interim and in the event of his arrest, the petitioner shall be enlarged on bail of rupees 50,000 with a suitable surety of like amount to the satisfaction of the arresting authority under the condition that the petitioner will appear before the IO within 1 week and cooperate with the investigation. Number 2, the petitioner shall not exercise threats to the witnesses or try to influence them, and the petitioner shall not leave the jurisdiction of the court without prior permission. On breach of any of the bail conditions, bail order shall stand automatically cancelled.
Deeply obliged,
Interim
madam.
bail order shall stand.
Deeply obliged.
May it please your lordship, not to pass over the matter for the time.
I can repeat.
May please, my lord. My lord, previous bail application, my lord, FIR. There are cross FIR, my lord, by the petitioner number 1 also and the informant also. The first FIR, my lord, page 11. It is, my lord, this assault, my lord, in the family, my lord, between, my lord, the daughter-in-law and my lord, the mother-in-law. Petitioner number 1 is the daughter-in-law, my lord, and the informant is the mother-in-law. Very long, my lord, FIR. It runs to 3 pages, my lord. Case register, my lord. Attempt to murder. This is not a case of attempt to murder. I am also mentioned, my lord. Of course, maybe the case of injury, because, my lord, on the date of occurrence, the next day, the informant came to Guwahati to attend birthday of the grandson. And thereafter, on my lord, thereafter they returned to her place, that is Kalaigaon, my lord, the district of Udalguri. My lord, is a very long affair, my lord. They say section, my lord, 61(2), a conspiracy. Section 1172, like grievous injury. Section 109, the attempt to murder. It cannot be a case of attempt to murder, my lord. Police, my lord, although register a case, my lord. The informant, my lord, they traveling, thereafter also traveling, not hospitalized even. So, my lord, the police could, my lord, issue notice, but that is not issued, my lord, due to the section, my lord, 109. This is the attempt to murder, although it is not a case of attempt to murder, my lord. But, my lord, still, my lord, your lordship may call for the case diary, my lord, and, my lord, interim protection will be given, my lord. These are both the lady, my lord, both are sister.
Yes. Mm. Mm. Mm.
Yes.
Mm. Mother-in-law. Oh, daughter-in-law.
Number 2. So, my lord, I am not going to entire part of the my lord affair.
Mm.
But page 12, my lord, one line item of around that I was previously hurt by the accused number 1 and 2 in the course of the people. Hearing upon the after the fact. And my lord, in the same parameter, the later parts, my lord. And then instructed accused number 1 and that we and partly the left the factor of my is the part the part of the affair.
My lord, second
And
paragraph
then
of that page.
my lord, another affair was also lost by my lord, accused number 1, my lord. And my lord, that was after because my lord, the first affair is I think the cross affair that was kind of 12 after launching of this. That's kind of
Well, para 12.
Just a moment. Just
page
please
12.
sit down. Just a moment. I'll go through the FIR and then I'll decide. Please sit down. It'll take some time, long FIR.
Yes.
What are your grounds?
Well, my ground, my lord, so far the fracture part is concerned, my lord, while my lord, the order passed by the court below, my lord, this is not mentioned. So far the injury is mentioned, injury is there, but no fracture. Had there been fracture, my lord, it should have been, my lord, mentioned here. I'm, my lord, reading page 18 and 19. 18 is the order. Last portion, my lord, 19 of the, this is the order, my lord. Last portion, my lord. On perusal of CRCD, it transfer the acquisition against the accused persons are under section so and so is the BNS connection with Calago PS case number. There is overwhelming incriminating material against the accused person and perpetrating of alleged offences. The medical report suggests that the victim sustained grievous injury. Considering the above, in my opinion, bill rejected, my lord. But my lord, if it is, my lord, grievous injury, assuming that, my lord, is up to 7 years, punishment is 7 years. In that case, my lord, as far Ernest Kumar case, my lord, police what my lord, is to notice. And my lord, my FIR is also, my lord, page 16. That the petitioner number 1, my lord, the FIR is page 16, my lord. See, regularly, my lord, if you after the death of the...
Okay. Heard learned counsel, Mr. B.S. Chauhan for the petitioners. শ্ৰীমতী দীপানিতা বৰা আৰু দুগৰাকী আছে নহয় চাই দিবা চেপ্টেন জয়শ্ৰী চৌৰীয়া Full stop. The petitions have filed this application under section 482 of the BNWS 2023 with prayer for pre-arrest bail as they are apprehending arrest in connection with so and so PS case under so and so sections. Heard Mr. K. Bosher, learned additional PP Assam. Full stop. The learned additional PP has raised serious objections stating that the FIR clearly discloses that the petitioners have assaulted an old woman aged 69 years. Full stop. The order dated 16/12/2024 passed by the learned session judge Udalguri in Miss B 214 of 2024 suggests grievous injuries sustained by the informant. It is submitted on behalf of the petitioners that the petitioners are housewives, and in the event of the arrest, their children will suffer immensely. It is further submitted that the petitioners are local residents and they will cooperate with the investigation. Full stop. No notice was issued against the petitioners, considering the fact that this offense is relating to grievous injury. Full stop. I have considered the submissions at the bar with circumspection. Stop. It appears that interim bail may be granted to the petitioners. Full stop. I have considered the submission that the petitioners are elderly, that the petitioners are local residents and they are not flight risks. Full stop. I have also considered the submission that the petitioners are willing to cooperate with the remaining part of the investigation. Full stop. In the interim and in the event of the arrest, the petitioner shall be enlarged on bail of rupees 50,000 each with a suitable surety of like amount to the satisfaction of the arresting authority under the conditions that : or Roman 1. The petitioner shall appear before the IO within 1 week and cooperate with the investigation. Number 2, the petitioner shall not exercise threats to the complainant or other witnesses. Number 3, the petitioner shall not try to influence the witnesses. Number 4, the petitioner shall refrain from such activities with which they are alleged. Number 5, and the petitioner shall not leave the jurisdiction of the court. Stop. Next paragraph. On breach of any of the bail conditions, bail order shall stand automatically cancelled. List on second.
First meeting.
Call for a CD, list the matter on.
Please, Your Lordship. Lordship, in this matter, CD may be called for.
Call for a CD. NDPS, POSCO,
No, Your Lordship.
death.
P10 allegation of deputy is there, Your Lordship.
Call for a CD, list the matter of.
Second one, fourth or fifth. Oblige.
May I please, Lordship, this is an application under 483 of the BNSS. So this is a family, husband and wife dispute, Lordship. Can you turn up at page 14 regarding the affair? So, Lordship, she has admitted this fact that she has lost a false affair, Lordship. Kindly, the mobile message is also there. Kindly turn up at page 25. She admitted this fact. She has lost a false affair. Actually, the fact is that Lordship, she was twice she was caught red-handed while having an affair with her previous boyfriend. The petitioner tried to make him understand that whatever is gone, she should be with the petitioner only. But she got angry, then she told that she will take a legal action against.
Please
So
read
that's
the
why-
FIR.
Yes, Lordship. Page 14, okay. We do respect the informant beg to state that on 31/9/2024, my marriage was solemnized with the accused person as per Islamic rites and ritual. After 1 month of the marriage started mental torture upon me on demand of dowry. He kept me in the rented house at Kailipara after marriage. Though after 2 months of the marriage started residing at aforesaid residence of 6 Mile Juripar after leaving the said tenanted house. He physically tortured me in the state tenanted house also. On 3rd January inside my house, after wearing shoes, the accused person kicked me several times in my abdomen. Even not satisfied with this, he dragged me to the roof of the building of my house in order to kill me by throwing me from there. When I shouted, he stopped me. He stopped there. Thereafter, on 4th January at about 8 p.m., he dropped me to village named Garua by saying that he will took me to my matrimonial house. Sir, the aforesaid accused person is threatening us to shoot me and my mother with a pistol. Proof is there in the mobile. It is well known that he used to change his rented house as another 2 ladies married him prior to my marriage. Therefore, sir, after proper investigation of the case, Pani is the accused person. That is totally a false. He stated that it is known that he used to change his rented house another. So totally false. Never is first time he got married. So Shiv, this is a family dispute because the well-wishers are trying to settle the matter between the husband and wife. So if at this stage if it's arrested or Shiv, the situation between them will be deteriorated. So so considering on this point, the Shiv may be granted and may be protected. And kindly see the page number 25, the mobile message. Also, she has admitted this fact that like she falsely she has lost this case. She has admitted.
No, this is not admission.
So kindly say, she said that আৰু মোৰ ওপৰত মিছাকৈ থানাত মেণ্টেলি ফিজিকেলি টৰ্চাৰ কৰা বুলি কলি আছো আৰু কি যে হ'ব একো নাই দে তাৰপিছত নেক্সট পেজ 25 আৰু
This is
মোৰ
not admission.
No, she did not deny the fact. Also, my humble submission is that at this point, if the petitioner is arrested, what will happen is the violation trying to settle
How can
the
I come to know that this is his phone number and this is the other phone number is hers?
She has given the phone number in the FIR also, no? Okay. FIR phone number, accused person phone number is there. Her phone number is also there. First page, Lordship, page number 14. Accused person Muhammad Nakibuddin Ahmed, Rubul Ahmed, son of late Hilaluddin Ahmed.
No, this is not the same phone number.
Lordship, his phone number is there. Lordship, phone number 99541 99541 35659.
No, 99547, not 541. Not the same phone number. We'll call for a CD.
Oh, sure, at least interim
Short
protection will
date.
be given, Lordship.
What do you say?
The interim protection will be given, otherwise.
Hmm. Hmm.
Lordship, otherwise the situation will be remain. Oh, really should are trying to settle the matter between them.
In that Assamese version.
My lord, in the FIR, my lord.
Hmm.
But the particular part,
Hmm.
page my lord 20, my lord. Page 20, my lord. So adopted the photo, my lord. There are my lord, Tariq, my lord. This 2025.
40.
Yes.
Yes.
And my lord, in the my lord, Hyderabad part, my lord. The meat of the paragraph. Was what is not telling that company. Bakura, lot of people, okay, today को सेवा वालों पूरी है तो then there also you have to carry the point very yes but otherwise
Continuing offense. Starting from September to January to.
from the date of marriage.
So, Lordship, she has stated this technology. She has logged this case
J.
because
Pal, learned counsel.
the interim
for the-
protection will be
Yes,
granted.
yes, learned counsel for the petitioner. Nakibuddin Ahmed alias Rubul Ahmed, who has filed his application under section 482 of the BNWS 2023 with prayer for PRS bail as is apprehending arrest in connection with so-and-so PS case under so-and-so sections. Heard Mr. K. Bosher, Edition 50 Assam, full stop. I consider the submissions at the bar. The allegation against the petitioner is that since the date of his marriage with the victim, the petitioner has been subjecting the victim, the petitioner has exercised physical and mental cruelty to the victim. Has subjected the victim to physical and mental cruelty. He even threatened to shoot the victim and her mother with pistol. I consider the submissions at the bar, full stop. The learned counsel for the petitioner has I've considered the submission that the petitioner is willing to cooperate with the investigation. Full stop. The petitioner is a local resident and he is not a flight risk. Full stop. The petitioner is willing to abide by any stringent bail conditions if imposed upon him. Full stop. It appears that interim bail may be granted to the petitioner. Call for a city list the matter on. In the interim and in the event of this arrest, the petitioner shall be enlarged on bail of rupees 30,000 with a suitable surety of like amount to the satisfaction of the arresting authority under the condition that the petitioner shall, under the conditions that colon D hyphen deliver. Number one, the petitioner shall appear before the IO within 1 week and cooperate with the investigation. Number two, the petitioner shall not exercise threats to the witnesses and try to influence them. Number three, the petitioner shall not leave the jurisdiction of the court without prior permission on breach of any of the bail conditions. Bail order shall stand automatically cancelled.
Under 22.
Obliged, Lordship.
May it please, my lord, PRS bill application. My lord, your lordship may turn to page 26.
Page 26, yes.
My lord, it is a seer case your lordship will find. Complainant is the victim. Name of accused is me. And my lord, date of occurrence was 24/12/24. 24/12/24, your lordship will give. Now the FIR, I will read it, small one. The most respectful is beg to state. Accused person is a very cruel and wicked man The accused person is a neighbor of the complainant in the same village. The accused person had marital transaction with the husband of the complainant. On the date of occurrence of such and such in the evening, the accused person came to the house and being asked whereabouts the husband of the complainant, and when he came to know that the husband of the complainant is not at home, the accused person, by entering the room, tried to rape the complainant, forcibly by falling her on the ground. Then the complainant and her children started hue and cry. Then the other person of the house witness came, and by entering the room, seen the ill deed, the accused person went away, leaving the complainant. The accused person has outraged the modesty of the court, taking advantage of the rules, take necessary steps. This is the FIR, Bharat. Your Lordship, now down to the original one. Your Lordship will find at page 31. Date of incident was 24/12/24. It was a CR case which was registered as Nilam Bajar PS case on 8/1/25, and it was filed at page 31. Your Lordship will find right hand side top 27/12/24, page 31. Your Lordship has got it, the original. It was filed on 27. Incident occurred on 24, and it was registered on 8/1. Now I take your Lordship to page 15, 1/5.
Incident of order 24.
And it was filed on 27, registered on 8/1. Now I take your Lordship to page 15.
Registered on
8/1/25.
27, filed on 24, registered on 8/1.
8/1 and
Yes.
and it was CR case was filed on 27/1/25. 27/12. CR case was filed on 27/12/25.
Yes, I have marked it.
My Lord, now page 15, your Lordship will find. This is the now one earlier CR case filed by the informant's husband against me, where the date of occurrence was stated as 23/24, 1/11/24. Page 15, your Lordship will find. Date of incident 23/24, 1/11/24. Everything that he borrowed 1,40,000 from me, and the last paragraph your Lordship will find at page 16. Under the aforesaid circular, at last on 1/11/24 at about 8 p.m. at night, the accused person came to my house with some unknown person scolded me. Then, on being protested by me and my wife, the accused person punched and kicked me. When my wife tried to escape, the accused pulled the clothes of my wife with the ill motive to put his hand on the body of my wife. All these incidents, when it was filed, the court held that directly will not give it for registration. They issued notice. Next page, your Lordship will find page 30. Court issued notice to me. Page 20. Sorry, page 20. Page 20. They issued notice to me.
Yes.
The moment notice was issued, their ill motive that police is not going to arrest me, they have filed another complaint where they have not stated a single thing of the previous one. They have suppressed. The only issue is this: he took 3,50,000 from me for purchase of a vehicle. I have annexed all those documents, and the condition was that after the vehicle will be run, we will divide the profit 50/50. But if it is sold by the person, the informant's husband, then he will return me 3,50,000, which he has not done. And I have to file a, my lord, money suit. That is at page 22. Page 22, this money suit, I have filed it, and page 25 is the prayer of returning back the 3,50,000. And the money and the agreement that on the basis of which I have filed is at page 11. Agreement, page 11 is the agreement, and the vernacular is at page 13. So, Mala, these things, it resembles that, Mala, it is a totally in motive only to not to return me the money that she, both the husband and wife are filing one after another CR cases. But in the second FIR for which has been registered, I have come before your Lordship. They have not made a single whisper that there was a FIR filed, earlier incident occurred or something like that. So it itself shows their malafide intention. There nothing of that so incident happened, and only to
No,
harass.
just mention about the money suit in the second FIR.
My lord?
Not money suit, about the borrowing money. They have mentioned.
My lord, they said that there is a money transaction. The accused person had monetary transaction with the husband of the complainant.
Then it is there.
But now, but that is the reason why they have doing all this, madam. They have not mentioned anything about the earlier CR case. That there was an incident in March, then it was incident in January. Why they have not mentioned? The moment notice was issued by the court to me, then they found that the police will not register the case. I will go before that court. They have issued file another CR case. The CR case was at page 15, and notice was issued to me. The moment notice was issued, they have filed this CR case through the wife. Virtually the same thing they have repeated, same thing.
Yes.
Just to harass me, my lord. And one thing that was subject to all my restrictions, my lord. 75 is my lord, sexual harassment with extend to 3 years, and next is 63, 64 punishment for rape. Here tried to rape. The question of 63 and 64 will not come. It's a case of 75 maximum, which is 3 years. So, my lord, because there is a statement made that tried to rape, not rape. So 63, 64 will not come. No further 24, 12, page 15. 23.
But otherwise, my lord, that is the regarding the that was
With due respect to my friend, my lord, can I make a small submission? But if 63, 64 is not there, the moment 75 is there, the question of my lord giving notice will come. Because it is 3 years that Anesh Kumar will come. So, my lord, let the CD come, my lord, give me the protection. I am a businessman, my lord. For no purpose, I will be harassed. They have admitted they have taken money from me.
Earlier, they have alleged that the incident of sexual assault took place on 1/11.
They have stated in the my lord, vernacular at page 70, you also will find ঘটনার তারিখ 10-3-24 1-11-24. Two dates are given in my lord, 23 March and in November. 2 dates of gap of how many months, my lord? Around 7 to 8 months. And it was filed on 12 December, 10 December. So all my lord, it itself shows their intention is that just to harass me, that why I filed this money suit for getting the money back. A man cannot wait, or a lady cannot wait for from March to December to file a case of sexual harassment. And when notice was issued in that case, the moment notice was issued, they have filed another CR case. Hearing. Earlier is a it has been registered.
CR case.
Yeah. They have not gone to the police station.
earlier that was
Nilamba Jacob. So the your lordship can understand their intention. Why not they are going to the police station to file the. '74 and '75 sexual harassment was earlier 354. নোটিশ ইস্যু করলে করার লগে লগে আরো নোটিশ ইস্যু করিতে পারবে one they have not stated. They have not stated in the second CR case about the earlier case of the husband. Why not? Question? They have suppressed that. I will appear before the investigation officer. I give my statement. Everything will be done. If something very serious is there in the city, your lordship will well, if you please cancelling my prayer. লগে লগে আকৌ এটা
The earlier one.
The husband of the informant.
I don't know if the present case.
Is the wife. Wife. Earlier also the same incident, the moment husband filed, the moment husband. Correct, my lord. I have not suppressed that. I have made in my submission. Husband filed, notice issued. When they find the notice has issued, I will come before the court. Then they went with the wife to file it. Why they are in different dates of incident, and why the wife has not stated that my husband has earlier filed an CR case where that they have suppressed. Why they have suppressed that? Well, that should have been there in one case by CR case by husband, one case by wife.
I'll pass an order later. I'll pass an order later.
My lord, your lordship will find that, my lord, if recently in 482, the Supreme Court has said, even in a case of a major, it will be a case of a civil liability. If they say that there is a rape and others, it's not a criminal liability. This is quotation with others. I have given him one copy in 482, and even in AR 23, where in a 480 the court has held Justice Gawai with Padikas, Justice Malad.
Yes, it
Those
has
are
come
in
recently. You have the judgment?
Well, one judgment is there, my lord. Yeah, here is the judge, page 31, my lord, para 31, where it has stated, my lord, in our view, the community is to be attached with such prolonged physical relationship at a very belated stage. Here it is happened. It can be lead to serious consequences. It will be open. Also, it will open the scope of imputing criminality in such long-term relationship after turning so. As such, allegation can be made even at a belated stage to drag a person in a juggernaut of stringent criminal process. There is, al-
Please give it to me. I'll
Yeah.
read it again.
there is always a attributing criminal intent as to otherwise disturb civil relationship of which court must also be mindful.
Which paragraph?
Para 31. And para 31, and my lord, and it has said, my lord, it has para 37, the court has said you can go for seeking other remedy. Before it, application.
Now she is a responsible woman. If any perjury can be proved, she'll be held responsible. In POSCO case, we cannot help the
It is not a POSCO.
hold the victim liable in
Well,
POSCO cases, sir, because they are below
This is
18.
not a POXO case, my lord.
So in such cases, she has to be careful also.
My lord, because same incident, virtually husband lost, notice issued, malified intendance, again the wife files.
I'll pass an order later. I have noted everything. Yes, yes.
Sorry, madam, it is another court, madam.
Yes, yes.
In this case, earlier also this same petitioner came, madam, not same petitioner, same case, but on the other petitioners accused, madam. Page 10, your lordship might be remembering that in Brahmaputra Delhi Academy, that function was there and one person was killed and all
Yes.
that madam. So now
One
with
advocate
this
was also involved.
charge sheet, first charge sheet filed, then final charge also filed. The main charge sheet 4 persons were my prima facie case was found.
That case is, that advocate's case is also fixed for
It
CD.
is actually 21st.
Then we'll fix it on 21st. We'll call for the CD. Scan, oh, yes, yes.
Yes, scan copies
Call,
of
call for the scan copies of the trial court record along with the scan copies of the CD. List the matter on 21st.
Yes. This is what your lordship kindly see, my lord. I just take it to your lordship to the FIR, madam. Page 16, page 16. Then I'm total your lordship will find 1, 2, 3, 4 persons named in the FIR. Allegation is your page 17, my lord. Let us read, then it will be clear, my lord. In fact, that the accused number 1 and 3, your lordship kindly 1, I am number 1. And 3 called us. My mother, Jarina Khatun, Halima Khatun, etc. About 7 persons. 7 in courtyard of accused number 2. So I and accused number 3 called the informant and some other person in the courtyard of number 2 for the discussion to enable us to go to Umrah Hajj, my lord, Makkah. By making estimate of rupees so and so 1,05,000 each person, my lord, total amount 7 lakh, to which you have paid to the accused number 1, 2, and 3 through phone pay. Along with these 7 persons, the accused number 1 and his wife, Amela Khatun, also discussed about Umrah Hajj. But as the visa was not done, for which visa was again applied for second time and obtained the same, but the accused number 3, who took the responsibility of the Umrah Hajj, has taken us to get ready for Umrah, and hence they called their respective relatives and thereby spent rupees 2 lakhs for feast. Prior to the date of going on Hajj, all the Hajj pilgrims were called by the accused number 3 at the courtyard of accused number 2 and given details about the Hajj. But it is my misfortune that the accused number 3, who took responsibility of Hajj, went absconding. 3 got absconding. He is also unavailable over phone. Be it mentioned here that accused number 2 kept all the necessary documents such as passport, visa, insurance, and bag from the Hajj pilgrim. When we went to inquire about the accused number 3 at the house of accused number 4, then she asked to go back by stating that she is not willing to talk with the other people. Giving assurance of taking us to Umrah Hajj, my misreporting of so and so, and money, and also spent money in the feast and thereby caused mental and financial harassment to us. So this is the main matter. Now, so far the present petitioner, he is number 1. He has actually applied for his wife's passport, matter. He also wanted to Umrah Hajj means my mini Hajj. Main Hajj is it is for about 45 days. And the mini Hajj it is for 10 days to 15 days. People anytime they may go, my. So for that, my lord, this 1 that is present petitioner, his wife also applied for passport. For some reasons, passport, because of mismatch of the name, my lord, passport could not be obtained. So cancel. Other two petitioners said that since I have paid the money and my wife visa is cancelled, so you may take some other person and from them you may give my money. I introduced only matter 2 and 3 and 4. This is my only, nothing, no other allegation against me, my lord. Against me, allegation is that, my lord, that I introduced those persons. This is the allegation. So in other case, one of us already given interim, my lord. This we have, my lord, enacted. Page 23, your loss. Same footing, my lord. Page 23. Give me a pen again. Yes. No, I can take the question. Yes. Page 23, my lord. Accused number 2.
Yes, what do you have to say?
Yes. Yes. 2 is that person who got the interim. Page 23, but 1, 2, and 3, they say. That question raised last time also, man. There is no question of my payment to me because I have nothing to do. I simply introduce them, man. CD will reveal everything, man. And it is next date fixed is matter on 22/4/25. Same matter. 1, he is 2, man. On same footing. Just I lift your worship, man.
Okay, I will pass an order later.
Same footing, man.
Understood.
That is my own question.
Item 24.
Well, in this case, my lord, the quarrel is in the same family lordship. Now, kindly see the affair lordship at page 11 lordship. My lord, name of the my lord complainant, kindly see Sohor Ali lordship. He is the son of the my lord accused number 4. He is Nur Muhammad, my lord. Nur Muhammad Ali was arrested lordship. He is in jail lordship. Now, others lordship accused number 5 is my lord the second wife of the accused number 4, Nur Muhammad lordship. My lord 4 is my lord daughter. My 4 is daughter lordship. And my lord, sorry, she is daughter lordship.
Complainant is son of accused.
Yes, lordship. My lord, son, my lord, land dispute lordship. My lord, my land, my lord, the land of the my lord accused number 4 was my lord wanted to be sold by the my lord second wife, first wife lordship. And my lord application was submitted. Arrested my lord, main my lord person my lord Nur Muhammad had been arrested lordship.
He has been arrested.
Yes, lordship. My lord, others are my lord, wife, my lord, daughter, my lord, son-in-law, my lord, nephew, my lord, same family, my lordship. This is a my lord quarrel because of land dispute. My land was of the accused number 4 was my lord wanted to be sold by the my lord. Very disturbing lordship. Now,
একটু স্পিকারটা অফ করে দিলে ভালো হবে নাকি?
my lord, first wife lordship submitted application for NOC, my lord. The husband, my lord, raised object.
Of which not accused.
My lord, all the accused except 4 lordship. He is in jail lordship. My lord, 1, 2, 3, and 5 lordship.
1, 2, 3, and 5.
Lordship. My lord, NOC was application was rejected on the objection raised by the my lord accused number 4. My lord, this saying that the land is in the north. She was not part of the lordship.
Mother stays with the son or what?
Lordship.
Mother stays with the complainant.
Yes, lordship.
Father stays with the accused and mother stays with the
My lord, one mother is my lord with the my lord husband, other is with my lord son. My lord, father was my lord brutally my lord assaulted lordship. There's some quarrel is there because of my lord land, my lord. This is a my lord internal matter lordship.
Yes.
Yes, lordship.
Title suit, title suit is also their lordship. Now kindly see the FIR lordship. Lordship, kindly see, my lord, where is the injury, lordship? Nothing. In the FIR, there is no injury, lordship. Yes, lordship. My lord, no injury is not there, lordship. Lordship, yes, lordship, accept him, lordship, others. Will not be loved. It will, will not be granted. Yes. My lord, accused number 1 is lordship. Is Amez Ali, lordship. Different, he is arrested. So accused number 1. Yes, lordship, his petition number 1, petition number lordship, 4, lordship. Accused number 1 is petition number 4, lordship. Lordship, yes. Oblige.
It was your submission.
No, my senior was submitted.
Who was he?
He's Legonid code number.
What is his name? What was
MH Ahmed.
Huh?
MH Ahmed. MH Ahmed.
Oh, M.H. Ahmed. Third learned counsel, Mr. M.H. Ahmed, for the petitioners. The names are there, petitioners 1, 2, 3, and 4. For the petitioners 1, 2, 3, and 4. Who have filed this application under section 482 of the BNSS 2023 with prayer for pre-arrest bail as they are apprehending arrest in connection with so and so PS case under so and so sections. Heard Mr. R.R. Kaushik, learned additional PP Assam. Full stop. The learned additional PP has raised serious objection, stating that the FIR stating that the FIR and the forwarding report relating to forwarding of the arrested accused Noor Muhammad Ali clearly reveals that the accused stroke petitioners were armed with sharp weapons and they have collectively attacked the victim. So blood-stained clothes were also seized in connection with this case. Blood-stained clothes, CLOTHs. I have considered the submissions at the bar with circumspection. So it is submitted on behalf of the petitioners that no overt act could be attributed to the petitioners. Full stop. However, the FIR reveals that overt act has been attributed, OVERT, overt act has been attributed to the accused number 1, i.e. petitioner number 4, no? Amez Ali.
Lordship.
4 or what? 3.
Amez Ali, Lordship. Petition number 4, Lord.
Accused number 1, stroke. Petitioner number 4, Amez Ali, alias Amir Ali. Full stop. Except petitioner number 4, comma, it appears that interim bail may be granted to the other petitioners. Full stop. I have considered the submissions that the petitioners are willing to cooperate with the remaining part of the investigation and to abide by abide by any stringent bail conditions, if imposed upon them. Full stop. Next paragraph, the petitioners, Mohar Ali, number 1, number 2, Romana Khatun and Amirun Begum are granted interim bail, full stop. In the event of their arrest, the petitioners Mohar Ali, Romana Khatun and Amirun Begum are to be released on bail of rupees 30,000 with a suitable surety of like amount to the satisfaction of the arresting authority under the conditions. এইটো এনেকে লিখি দিবা, কোলন এটা দি হাইফেন এটা দি দিবা, তাৰপিছত তলত লিখা Roman 1 that under the conditions Roman 1 the petitioner shall appear before the IO, the above named petitioners shall appear before the IO within 1 week and cooperate with the investigation. Number 2, the petitioner shall refrain from such activities with which they are alleged. Number 3, the petitioner shall not leave the jurisdiction of the court without prior permission, full stop. On next line, on next paragraph, on breach of any of the bail conditions, comma, the bail order shall stand automatically cancelled. The petitioner number 4, Amez Ali, is not granted interim protection. List call for the CD, list the matter on.
Lordship, short bit may be given, Lordship. So say petition number 4 is not protected, Lordship. Then Lordship, it
Good, is it?
Item 26,
May I please your Lordship? Lordship, CD not available.
CDS call for is not received. Item number, CDS call for is not received. Issue reminder.
6.
List the matter on.
Lordship, I am on interim. The interim may be continued, Lordship. Much obliged.
25 to kilo. Oh.
May I please hold on? My lord, please follow the 483 application, my lord. The BNS petitioner behind the bar from 17/8/2023. Today is 1 year, 82 days. Kindly turn over to case number. Kindly see the election number 1, FIR, my lord. On the date of occurrence, 4 persons were arrested and from a car. 4 kgs Yuga tablet found from the 12 tank.
How many Yuga tablets?
4 persons, my lord.
How many?
4 persons and 4.892 kg.
4.892 kgs of Yuga tablets.
Yes. Thereafter, charge sheet was submitted. Trial already started after conclusion. 5 witnesses already. 4. 4 already. Out of 9, 4 PW examined. Out of 9.
And
On what ground you are asking bail then?
but the petitioner only suspicious ground, my lord, some tablet found from the
5 kgs of yaba tablets were not 4.892, almost 5 kgs of yaba tablets. Imagine 5 kg. Just imagine 1 kg yaba tablets. How much harm it will cause?
last PW was examined 7/1/25. Petitioner was not the owner, my lord.
I'm
So you
rejecting
must
it.
come to a
I'm rejecting it. Our learned counsel, Mr.
G.U.
A.
G.U.
G.U. Ahmed for the petitioner Abdul Muttalib, who has filed his application under section 483 of the BNSS 2023 with prayer for bail, as he is behind bars since 17/8/2023 in connection with charge
Submitted on
special
Submitted on,
special
dated 20
within bracket
11/20.
NAR bracket close case
27
number 153 within bracket capital M bracket close 2023 arising out of Manipur PS case number 151 of 2023 under section 22 within bracket C bracket close stroke 25 stroke 29 of the NDPS Act. হেৰি আৰু আছে কেইটামান section হা 22 লিখিলা ন 22C stroke 23C within bracket C stroke 22 একদম beginning of 22A লিখি দিবা small a 22 small a 22C 22 23C 25 29 গোটেইবোৰ হেৰিৰ ভিতৰত দিবা দেই within brackets A আৰু C brackets ভিতৰত দিবা NDPS Act. It is submitted on behalf of the petitioner that the petitioner's right to liberty has been infringed as he is behind bars for 1 year and 82 days, full stop. It is further submitted that the petitioner is innocent and has been falsely incarcerated for such a prolonged period. The learned additional PP, Mr. K. Bosher, has raised serious objection, stating that out of 9 enlisted witnesses, no? How many out of 9?
Out of 9, Lord. Four
Out of 9 enlisted witnesses,
4 examined.
four witnesses have already been examined. First off, I have considered the submissions at the bar with circumspection. Full stop. The trial is progressing at a regular pace, PAC pace. Full stop. At this juncture, it cannot be considered that trial is procrastinating and the petitioner's right to personal liberty has been curtailed. Stop. At this juncture, the UNCTURE, it cannot be considered that the conclusion of trial appears to be remote, REMOT. This is a case of grievous offense and the petitioner is facing trial for transporting 4.892 kgs of yaba tablets interstate, full stop. Considering all aspects, petition with prayer for bail is rejected at this stage.
May I please, Lordship? Actually, I am behind the hour for 52 days as on today, Lordship.
How many days?
52 days. Lordship, kindly use the vernacular FIR, Lordship, that is page 11. Handwriting is well, you Lordship, will take up the vernacular part.
Yes.
Only on suspicion, Lordship, that the present petitioner has been arrested.
Please read.
Yes. সন্মতপূর্বক বিনীত নিবেদন এই যে মঙ্গলবারে রাতে প্রায় 11 মান বজাত মোর ঘৰৰ বাৰান্দাৰ খেলাখোৱা মাৰুতি কাৰ 9 উল্লেখ আৰু ৰেজিষ্ট্ৰেশ্যন নকৰা এখন নতুন স্কুটি পৰিকল্পিতভাৱে এটি টায়ার আৰু পেট্ৰলৰ সহযোগত জ্বলাই ভূচুৰিত কৰে। গাঁৱৰ ৰাইজ আৰু জুই নিৰ্বাপক গাড়ী সহযোগত ঘৰৰ ভিতৰত সোমাই থকা 6জন ব্যক্তি কোনোমতে প্ৰাণ ৰক্ষা কৰে। সন্দেহভাৱে মানে দিছ ইজ ইম্পৰ্টেণ্ট। সন্দেহভাৱে ওপৰত উল্লেখিত অপৰ পক্ষ দুজনে যোৱা 12-1-25 তাৰিখে মোক প্ৰাণে মৰা ভাবুকি দিছে। This is the allegation.
You have the CD, no?
Yes, sir.
What do you have?
Only on suspicion he was arrested, Lordship. But after confrontation was took place between the families, the informant families and the petitioner families. So he was on the basis of suspicion that he made the victim culprit for Panda, made the fire. Lordship.
In fact, on that day, Lordship,
Their entire vehicles were burned
Yes,
to ashes.
all assist. Report from the
in fact, on that day, Lordship,
Fire-
I was in Guwahati.
only on basis of the suspicion, even the case direct. Witnesses has not indicated him, but
In the FIR itself, that is.
they are stating that he may be.
For learned counsel, Mr. M. Khan, for the petitioner Raju Bora alias Dilip Bora, who has filed this application under section 483 of the BNSS 2023 with prayer for bail, as is behind bars since 24/1/2025 in connection with so-and-so PS case under so-and-so sections. Heard Mr. D.P. Goswami, learned additional PP Assam. I have considered the submissions at the bar. Full stop. The allegation against the petitioner is that he had a dispute, he had a quarrel, no?
Yes.
He had a quarrel with the informant on 12/1/2025. And on 14/2/2025, the informants Maruti car bearing registration number AS22E5245 and one bullet motorcycle, no?
Lordship.
Bearing registration number, oh, one new bullet motorcycle. Without registration number. Oh, no.
Scooty without number.
Oh.
Bullet, there is a number.
One new bullet motorcycle, no, one bullet motorcycle and one new scooty were burned. Full stop. Strong suspicion rests on the informant due to the quarrel on due to the quarrel, 2 days prior to the incident of arson, ARSN, arson. I have also scrutinized the case diary. Investigation has progressed substantially. I have also scrutinized. Investigation has progressed substantially. The merits of this case are not brought to the fore, as investigation is still under progress. Stop. Considering all aspects, the petitioner is enlarged on bail of rupees 30,000 with a suitable surety of like amount to the satisfaction of the
CGM
Dhemaji under the condition that the petitioner shall appear before the IO on every fortnight till completion of investigation. Number 2, and the petitioner shall not leave the jurisdiction of the court without prior permission. Stop. On breach of any of the bail conditions, bail order shall stand automatically cancelled. Send back the CD.
May Mr. Lord. Petitioner is there here, he received without PM report received, but there is no opinion regarding that. FSL report is waiting. Today's 76 days. FIR is on page 12. Otherwise, my eyewitness statements are here. 164, 150 statement is also here.
Okay, then we'll go through the statements only. Not required then.
Yes, madam.
Are there incriminating materials?
Yes. The eyewitness statement are here.
Let me get.
One lady died, madam. Actually, there are two cases. One, my lord, Bodarpur 311/24, and another was, my lord, Bodarpur 8/25. Both are because one injured person also lost the FIR. Subsequently, both were tagged. My lord. In my lord, in case of that 8/25, their injury report is not here, my lord. But otherwise, because since it has been tagged, so that because they beaten up 2 persons, one lady and one male, and that lady subsequently died. Her report is awaiting, my lord. Item number 50 also. You understand? 50. Item number 50 also. Okay. 50 also. Item number 50.
Okay.
50. 5 minutes. Okay, later.
28, nothing to keep. I'm rejecting it straight away. I'm rejecting it.
Today is 76.
Yeah, therefore I'm rejecting it. There are eyewitnesses account and that FIR, we do not want the FSL report or any doctor's opinion.
Lordship, in second case, item number 29. The petitioner number 1 and 5, I am not pressing because they are already arrested.
Item number this one, no?
Item number 29.
Item number 29 likha. Learned Counsel Mr.
Yes, sir.
S. Das has submitted that the petitioners have already been arrested and has become infructuous.
1 and 5 only.
1 and 5.
2, 3, 4 not. I have filed petition by making 1, 2, 3, 4 and 5. There are 5 petitioners are there.
Okay. I'm rejecting it. There are account of eyewitnesses.
2, 3, 4 are lordship, female and housewife. But they are equally involved. In fact, they are more involved.
This is, I think, moral policing.
I know.
Rejecting it.
Item number 50, the petitioner is on interim. The only one lady is there. He was given interim because considering being a female, my lord. But after going to the city, my lord, our involvement is also.
They are all named.
Yes.
By one eyewitness under section 164 CRPC. And 161 CRPC, it's needless to say.
But item number 50 is there is a separate FIR.
This is when there is a case of mob lynching. This is the most brutal offense. Actually, even when we discuss about death sentence, mob lynching cases are set as example. This is a mob lynching case. I'm rejecting it. All the items, even the lady who was granted interim bail.
Okay, then Lordship may clarify everything under section 164 also.
No, why should I mention all this?
No.
It is not required to be mentioned. You'll get a copy. As soon as charge sheet will be submitted, you'll get a copy. গোটেইখিনি ক্লাব কৰি লিখি দিলে ভাল হ'ব না? পাৰিব? ক্লাব কৰি লিখি দিবলৈ? নে এটা এটাকে লিখিবা? হয় নেকি? হেৰি কন্ট্ৰেকচুৱেল নেকি? নট এন এপইণ্টমেণ্ট। বেলেগক পঠিয়াই দিবলৈ কোৱা। গীতাৰ্থৰ লগত এপইণ্টমেণ্ট আছে। বেলেগক হেৰি মিনু নাইবা হেৰি কোনোবা এগৰাকী আহিব। ঠিক আছে তুমি যোৱা, মই বেলেগক মাতি আছো লাভ কৰি। সেইখিনি ক্লাব কৰি দিবা হা, এটাৰ পিছত এটা আইটেম নাম্বাৰ লিখিবা।
28, 29, 13, 50.
গোটেই আইটেম নম্বৰ 28, 29, 30 আৰু 50। সাপ্লিমেন্টাৰীখন ক'ত গ'ল? আছে 50, 50,
50. Only 50.
50।
50.
আচ্ছা 50।
Main list.
লাষ্টলৈ আছে ডেইলি লিষ্ট 50 হা। ক্লাব কৰি লিখি দিবা পাৰ্টিজৰ নাম দেখি উইথ কৰি পেলাই এণ্ড কৰি লিখিলেও হ'ব।
And item number 29, I am not pressing for 1 and 5.
1 and
5.
28,
29. Item number 29.
30 or 50. Yeah. You have for 50 also, no?
Yes. 1 and 5 already arrested.
Council Mr. S. Das, no? For the petitioners, দুজন petitioner আছে 1 and 2, in connection with BA number 408, comma, for line ke likhiba, next line, for the petitioners 1 and 5 you are not pressing, no?
Item number 29, 1 and 5.
For the petitioners 2, 3 or 4, huh? 1 and 5 no, 2, 3 and 4 in connection with BA number 343 of 2025. Next line, comma, for the petitioners for the petitioner, Yunus Ahmed in connection with BA number 476 of 2025, and for the petitioner, last line to likiba, Farhana Begum in connection with BA number, AB number 413 of 2025. Excuse me. Ola Bodapur PS case number 8 of 25. No.
One is, first two cases are 311 and
2 FIRs have been hardly to cut here. Hard learner additional PP Mr. R. Koshik, additional PP, Assam Mr. R. Koshik. Full stop. I have considered the submissions at the bar. Full stop. It is submitted at the bar that 2 FIRs arising out of the same cause of action have been lodged. Full stop. 1 FIR was registered as Bodapur PS case number 311 of 2024 under sections 117, 109, 1032 within bracket 2 of the BNSS 2023 corresponding to GR case number 226 of 2024, and the other FI was registered as Bodorpur PS case number 8 of 2025 under sections 61 within bracket 2 bracket close stroke 191 within bracket 2 stroke 191 within bracket 3 stroke 126 within bracket 2 এনেকে লিখি দিবা section কেইটা গোটেইকেইটা stroke 117 within bracket 2 stroke 109 stroke 118 within bracket 2 of the BN single SD BNS 2023 comma corresponding to GR case number 52 of 2025. The allegation against we'll split it. That two FIRs will split it. uh, 25 or 26 connect. 28
and 29.
28 or 29 to attack FIR. বাকি তলকেইটা কাটি দিয়াচোন কেছ নম্বৰ এইকেইটা কাটি দিয়া 476 আৰু 413 এইকেইটা কাটি দিয়া 408 আৰু 343 টো থাকক আছে ন তাৰপিছত বাকিখিনি কাটি দিয়াচোন বাকিখিনি কাটি দিয়া বাকি arising out of the same cause of action টো কাটি দিয়া arising out of the same cause of action দিছিলো না or the two FIRs have been lost arising out of a good technique কাটি দিয়া এইটো bail application number 408 or 25 or 343 of 2023 and হেৰি লিখি দিবা additional PP The petitioners are accused named in the FIR lodged by Ainul Haq, wherein it has been alleged that on 25/12/2024 at about 10 p.m., the petitioners, along with the other accused named in the FIR, accompanied by one Selimuddin, went to Anwara Begum's in-laws house with false accusation that Anwara Begum and Selimuddin have indulged in an illicit relationship. Full stop. Then the accused persons named in the FIR tied up the hands and legs of Anwara Begum and Selimuddin and assaulted them. Full stop. As a result, both Anwara Begum and Selimuddin sustained grievous injuries, and Anwara Begum, who was immediately taken to Sriguri Hospital for treatment, succumbed to her injuries. The learned additional PP has raised serious objections stating that there are incriminating materials in the case diary against the petitioner. Stop. The statement of the witnesses under section 161 and the statement of an eyewitness under section 164 CRPC clearly implicates that the petitioners are complicit. I have also scrutinized the case diary. Full stop. A mob had indeed attacked the victims, which resulted in the death of one of the victims. Stop. There are indeed incriminating materials in the case diary against the petitioners. At this juncture, I'm not inclined to grant bail to the petitioners. Petition stands rejected at this stage. Send back the CD. Itia, item number 30 or 50. Our learned counsel, Mr. S. Das, for the petitioners. For the petitioner, Yunus Ahmed. In connection with BA number 476 of 2025. And for the petitioner Farhana Begum, in connection with AB number 413 of 2025, full stop. The petitioner Yunus Ahmed has filed the application under section 483 of the CRPC with prayer for bail in connection with Bodarpur PS case number so and so under so and so sections, and the petitioner Farhana Begum has prayed for pre-arrest bail in connection with Bodarpur PS case number 8 of 2025 under so and so sections. The FIR unfolds that the petitioner, that both the petitioners along with the other accused named in the FIR comma, both the petitioners along with the other accused named in the FIR on 25/12/2024 at about 8:30 p.m. confronted him about an illicit relationship between him and confronted the victim, a stroke informant, about an illicit relationship between him and Anora Begum. Anora Begum nilikiba, X likiba. Hai agor konoto X likiba. They then started assaulting him and forcibly confined him in the house of Siddiq Ali. First up, he sustained sharp injuries and he was knocked unconscious as he had sustained grave injuries as a result of the assault. Some other people of the locality came to his rescue when he raised alarm. The learned additional PP has raised serious objection, stating that although this case is registered on the basis of an FIR lodged by the informant, there is another case lodged by another informant, namely Altaf Hussain, no? Who is the other informant? Ainul Haq. Other informant, Ainul Haq.
Other of the victim.
Father of the victim X. So this, they have clubbed this case together.
Yes.
They have clubbed this case together. Amalgamated.
Yes. Okay.
Where is the order?
I have found on both. Order is there in item number 30, page number 70. But second case is only the injury.
The CD reveals that the order dated 31/1/2025. The learned edition PP has raised serious objection. लिखी नहीं. It is submitted that the CD reveals that the order dated 31/1/2025 in connection with Borderpur PS case number 8 of 2025, both the cases, that is Borderpur PS case number 311 of 2024 and Borderpur PS case number 8 of 2025 has been amalgamated and investigation has amalgamated and the IO was directed to proceed with the investigation and submit FF after amalgamation of both the cases arising out of different FIRs, because the cases are relating to the same cause of action and both the cases are relating to the same incident. Full stop. It is further submitted by the learned addition PP that there are incriminating materials in the case diary against both the petitioners. Full stop. The statements of the witnesses under section 161 CRPC, as well as the statement of the eyewitness under section 164 CRPC, implicates the petitioners. Full stop. I have also scrutinized the case diary. It appears that the petitioner Farhana Begum is not entitled to anticipatory bail. Thereby, the petition with prayer for anticipatory bail is rejected at this stage. The allegation against the petitioner Farhana Begum is of grave nature. there are two victims in this case. The victim X has already succumbed to her injuries. তাৰপিছত লাষ্ট এইখিনি তাৰ ভৰাই দিলা না আগত লাষ্টত লিখি দিয়া the interim order dated the interim order dated 21/2/2025 granting interim bail to the petitioner Farhana Begum is cancelled. The prayer for bail of the petitioner Yunus Ahmed also stands cancelled, considering the after scrutinizing the CD.
Yes, item number 29, 1 and 5, I am not pressing, they have already added, that may be online maybe.
Yeah, I'll add it later. He'll get confused. I'll add it later.
Instead of
Send back the CD.
61 and 164 statement, and the 181 and 186.
Oh, yes. 180,
1 and 80.
181 and 183. 161 or 164 there, 181, 183. B and double S লিখি দিবা এইটো সেন্ড বেক এখন এই সিডি খন থাকিব গোটেইখিনি
Item 31.
You actually you could have waited for this lady. She was on interim bail. You could have waited for the medical report.
Ma'am, please. Also, as per order dated 22/25, we have taken the steps, but the office note replied that we have not taken the steps. We have taken the steps for PP lots. Also, scan copy has not been received yet.
Item number
31. Also, we have taken steps as per order dated 20 February.
Learned Counsel Mr. Analom.
S.A. Bhakhtiar.
S.A.
Bhakhtiar.
Bhakhtiar is present for the petitioner and has submitted that that they had taken steps, although it has been indicated by the order dated hide office note dated order dated office note dated 12/3/2025 that no steps have been taken. Full stop. Service report on respondent number 2 is awaited. You have the CD?
Scan copy was called for.
Scan copy was called. Also, we will take fresh steps if not for.
The petitioner may also take fresh steps to issue notice to the respondent number 2.
That's it.
Or list the matter on
9 April.
32 also not a scan copy not received.
Scan copy as called for is not received. We should reminder list the matter on.
Okay.
Item 33.
God bless.
Please, your lordship, 483 application in connection with Mongoldo PS case number 14/25. Accused are behind bars since 57 days.
You have the CD?
Yes. But otherwise, there are intimidating materials are here, my lord. They are basically running a gang, my lord. They collect random account all over India, where the positive amount is used, my lord. Subsequently, they, along with some hackers, they hack those accounts, siphon of the money.
They're sending link and all, no?
Yes. Hackers, for a different.
Ito, comedy
Lordship, one of the co-accused has already been granted bail by the honorable bench, and whereby it was held that arrest itself was illegal.
How many days you are behind bars?
57.
I think only 1 day left, I think. No sessions tribal, no?
60 days.
60 days, no.
One of the co-accused is already granted bail.
Their credit will not come here.
They'll randomly collect accounts and they'll start hacking.
Yes, madam, because these two persons
My lord,
whole work,
all these allegations are only assumptions. They are
not assumptions, my lord, there are material. My lord, those persons, my lord, their job is to collect random accounts. They will take where the money is. Then they will plan, there are other hackers to whom to be transferring. Along with them, my lord, they will
They'll
hack the
basically
account.
attack the illiterate
They
people.
will hack the account, they will siphon off the money, and these two petitioners,
My lord,
with
no
others will
allegation
get.
from any of the accounts.
My lord, apart from them, my lord, they will get, my lord, this commission. Their statements are here, Koiku statements are also here, there are other transactions. Plus, there are other transactions which the police are verifying.
I had already 57 days, so.
Our
And one
learned
of the
counsel,
four accused is
Mr.
also you can't.
You can't for the petitioners, 1, 2, দুজন আছে, who have filed this application under section 483 of the BNWS 2023 with prayer for bail as they are behind bars since 20/01/2025 in connection with so-and-so PS case under so-and-so sections. Heard Mr. R.R. Kaushik, learned additional 50 Assam, who has raised objections stating that they are incriminating materials in the case diary against the petitioners. Where is the FIR?
It's on page 70.
It is submitted that it is submitted on behalf of the petitioners that they have been languishing in the jail for 57 days and they are entitled to bail on the ground of parity as a co-accused have already been enlarged on bail. The allegation against the petitioners is that they are members of a gang of financial fraudsters, financial gang committing financial fraud under the shelter of KP Residency, Mongolde. This gang used to hack bank accounts of different individuals and siphon off money from bank accounts of the innocent citizens. I also scrutinized the case diary stuff. Indeed, there are incriminating materials in the case diary against the petitioners. Full stop. I have considered the submission that the petitioners were willing to cooperate with the remaining part of the investigation. Full stop. I have also considered the submission that the petitioners are willing to abide by any stringent bail conditions if imposed upon them. Stop. Considering all aspects, the petitioners are enlarged on bail of rupees 30,000 each with a suitable surety of like amount to the satisfaction of the
CJ
Mongolde under the condition that the petitioner shall appear before the IO on every fortnight till completion of investigation. Number 2, the petitioner shall refrain from such activities with which they are alleged. And number 3, the petitioner shall not leak the jurisdiction of the court. On breach of any of the bail conditions, bail order shall automatically stand cancelled.
Okay.
Send back the CD. Can copies as call for is not received, issue reminder, list the matter on 4th April.
Publish. Article also case by notice.
Serious call for is not received, issue reminder, list the matter on. Are you on interim bail?
No, Your Lordship.
BA.
84 days, Your
So,
Lordship.
Harry,
On 19, on
90 days or 60 days?
90 days.
90 days.
103, Your Lordship.
Charge has been submitted. Okay. Learned counsel Miss S. Nazin is present. Learned additional PP Mr. KP Goswami has submitted that charge has been laid against the how many petitioner?
One.
Petitioner being CS number
25/25 dated 28/25.
The petitioner is at liberty to approach the jurisdictional court and apply for bail which may be considered by the court in accordance with law. CD scan copies.
CD, Lordship.
CD.
Lordship, in this case,
CD.
similar matter, Lordship, out of same FIR, Lordship, in AB, item number 43 AB. This is 483 application, Lordship, petitioner state on 21/12/2024. Today is about 86 days. Case is registered under section Lordship 1031/3 subsection 5 of BNS. Lordship. So as per FIR Lordship, kindly go to the FIR Lordship. At page number 10, translated copy Lordship. May I read Lordship? With due respect, I beg to state that about 20 years ago, from today, my elder brother Mujibur Rahman married the accused number 1, Junu Begum, who is the daughter of the accused number 2, and Tormuz Ali, and was staying at his wife's place. Since the past few days, the accused persons were torturing Mujibur Rahman and were also beating him. On 17/12/2024, the accused person attacked Mujibur Rahman with iron rod and caused him grievous hurt in his head, eyes, and other parts of the body. The accused person did not provide any treatment to the injured yesterday, that is on 19/12/2024. Some people from the village helped him get a bus to the village yesterday at around 8 p.m. He reached Kaplabari shop and called up his family members, and we bring him home from Kaplabari today, that is 2012/2024. We took him to the Mukalma Government Hospital and even.
All right.
So long.
If they receive, only thing is that the person has died but returned. So postmortem report we have not received yet.
That this
But
victim, he
it-
was alive, no? His
No.
statement has been recorded.
He died later on.
Died.
Later he died, but while he was taken, he was alive.
Alive.
But his statement is not here. But
He was
it is-
alive. Lordship, what happened in this case? He was staying for about 20 years in the in-laws' house. He has daughter and son. One petitioner is son, and Lordship, daughter got married. Everything is done there. He, due to some purpose, he visited his house. He is a mason by profession. He visited his house. He died there. There is some landed property, Lordship, and these persons enjoying this informant and their other family members enjoying this property. There might have some fight because of this property. They injured the person. They hospitalized without informing the family member. When his son and his son-in-law visited their house after getting the news of death of the person, then they were caught by the person and handed over.
You have something like this in the case diary?
No, Lordship. Only thing is that Lordship, he was a habitual drunkard. That's why, so hospital was going on frequently took place between the family members. That's why the assault part is there. The prisoner was assaulted. Later on, he was hospitalized. He was in a medical condition. But in the medical report, one report is here. That report shows that only medical checkup for he was in fact only medical checkup. That assault part is not in
You
the
have the
medical
postmortem report.
No, we have not received the postmortem report. That is the problem.
Let us
I kindly
call for the
consider
postmortem
the
report.
86 days, Lordship.
We will wait for the postmortem report.
Today is 86 days, Lordship. Today that
We'll need the postmortem report.
length of
That
detention.
case,
Length of
case-
detention may be considered, Lordship.
there is
Because
allegation.
though injury is there,
That
suppose
case not length of detention
Lordship,
cannot be considered.
supposingly they have assaulted the person, but that person went to their house.
There is 86 4 days within 4 days Friday. 86 Friday.
In that case, Lordship, on Friday.
Thursday. Thursday.
My Lord, in
4
that
days
case,
only Thursday.
today is 86 days.
Thursday or Wednesday. Wednesday koi dia.
Lordship,
This is from Guwahati or which place?
Kamalpur is nearby Guwahati.
Nearby Guwahati.
My Lord,
Wednesday nahibo. Kamalpur Wednesday nahi. Thursday koile thik hobo. Call for the postmortem
my Lord,
report.
can it be tomorrow, Lordship, if possible, Lordship?
Just now I have said that as it is from Kamalpur, it won't come on Wednesday. We'll fix it on Wednesday then.
Wednesday?
Yes.
When you have
And in the
Call for the postmortem report is not forwarded along with the CD. Call for the postmortem report. Retain the CD. List the matter on 19.
and other person, I don't know, 43 they were interim, no? They have
Interim order is
That matter may be taken up later on.
Interim order is appended up to day after tomorrow. 19, no? Okay.
My lord, I am not on that matter because that matter may be taken up some other day also. We are concerned about this because the person is in
No,
charge.
we'll dispose it of interim order, we'll dispose it of. We'll take up the CD, same CD, dispose it.
My lord, in that case, the second time medical report, postmortem report called for.
Same case.
Same.
Okay.
Obliged, lord.
Yes, about 37 or given 40, 36. Yes, 36 of
May kindly see the FIR, my lord, page 9 is one FIR against me, my lord, which is lodged by the one Dipali Kalita. My lord, with due respect, submitted on 19/10/2024 at about 10 p.m. at night. The above name accused without any reason has badly hurt my son Sri Khagan Kalita by a dao on his head and right hand at Jalukbari Chowk nearby our place. Now my son is under treatment at Life Safe Hospital by Vijay. My lord, actual fact is that my lord, may kindly see another FIR which was lost by
No.
wife of
Just
the,
a moment. You have any material?
we have not received the case diary.
We'll need the case diary.
My lord, it is shown in the
Serious call for receive issue reminder, list the matter on. Postpone.
No.
AB.
AB, Your Honor.
Postpone only.
No, not on the.
Why?
Milord,
Huh?
my friend is for the informant and with the
This is a POSCO case, AB 3132/2024.
No,
It's
that's
not
not
exactly-
That is a POSCO case by the informant against them, Lord.
Okay.
We are not
Against
coming
them.
under the POXO matter. They have brought into that matter in this case. This is not a POXO matter for which we are applying for anticipated.
Milord, I'm appearing for one of the victims. There are many materials that are required to be considered by this court. If I may pray, Milord, if I can file a objection in writing along with bringing some materials on record. My friend has filed certain materials, but I also would like to bring some certain things. And there are continuous breach of the bail conditions given in the bail earlier occasion to this client, to this petitioner. But there is continuous breach, Milord. Therefore, my lord, I strongly believe, Milord, Lord, people consider that whether this matter, in particular this case, whether it at all, this case requires a consideration for granting the privilege of clear restraint.
May I please, sir? Ms. Lordship, they have filed an objection recently in regards to if they have put any objection in the, we are restraining them in the police station. If so, Your Lordship, why the police station has not registered any case against us? No, this is all irrelevant. They have taken time
Not
after
at all
time.
irrelevant. In fact, the fact of the
Now,
matter is, Lordship will see that after filing our objection in the matter, we have filed one additional affidavit, Lordship. In the additional affidavit, we have specifically stated that when this informant before Lordship, he was, both these petitioners were earlier apprehending arrest in connection with an FIR lodged by them. When the present informant and one of our associates went to the police station, they were assaulted by this petitioner number 2, Babita Hajarika, inside the police station. And to that effect, Lordship, we have already lodged an FIR. And in that FIR, although case is not registered, but the information has been registered as a general diary entry. We have put it in writing. That is a part of the additional affidavit which we have filed.
That DD entry is in the Nagaon Sodar police station where they have stated that this happened in the Itasali police station.
Let
Why it
them
has
give
not been
objection.
stated?
Let them give
No,
objection.
Lordship, the thing is that this matter has been
You're not
pending for since
arrested.
long, Your Lordship.
Since
Let
long,
them
they are
file
enjoying the
objection. You are
protection
not
of
arrested.
interim bail, Lordship.
Interim bail for only one, Your Lordship. The CD has been retained from since long. The matter may be disposed
No,
of.
this is not CD. This is
This is a
LCR.
scanned copy.
No, CD was also there.
CD is also there,
CD is
Lordship.
also there. CD
Since we made specific allegation that they, Lordship.
No, scan copies of the CD maybe. We do not.
No. This is the scan copy of some other case wherein, Lordship, the present informant is a victim, Lordship.
Now, Lordship, they have made the entire thing very complex.
This is a very simple matter, your lordship, under section 61.
See, I'll just read out, huh? I'll just read out.
Yes, sir.
Scan copies, case record. No CDs here.
The CD was there.
You
it
have
was
the
been
CD?
written in the earlier occasion.
Then also your lordship requested up to the CD.
CDs up to which date?
From the side of the informant, one objection is
Let
filed.
them place an objection. Let them place their
They
objection.
have taken on 3 occasions, your lordship. They have taken time of filing objection, your lordship. Now again, the new victim has come over. They are filing an objection. Another again, in
There
this
is
way,
some
this thing has
miscommunication
been
he is trying
pending.
to confuse this honorable court. Objection is filed on behalf of the informant. I have filed it. I have filed one objection petition and another additional affidavit. Now my friend appears for one of the other victims, lordship. I am not appearing for that victim. I am appearing on behalf of the informant. He needs to file a counter, lordship, being a victim in this case.
Learned counsel, Mr. A. Hussain.
Yes, Ahmed.
Mr. S. Ahmed is present for the petitioner. Item number 30 है ना. Learned counsel, Mr. A. Ganguly is present for the informant, and learned counsel, Mr.
A. Sharma.
A. Sharma.
Someone.
A. Somo is present for the victim and has submitted for time to file an objection against this petition. Learned additional PP, Mr. D.P. Goswami is present and has submitted that the CD is not up to date. Send back the CD, call for the up to date CD, list the matter on 9th April.
Yes, sir.
The interim order shall remain in force till then.
Oblige.
Dear Lordship, my senior is in on the bereavement, so kindly adjourn the matter for today.
Learned counsel, Miss
M. Khatuniar.
M. Khatuniar has prayed for adjournment. As a
Let the
senior,
interim order may continue.
as a senior is in bereavement, interim order shall remain in force till the next day. CD is received.
CD, we have 2 CD was called for lordship. We have received that 33 of 24 Ramdul case number. But 32 of 24 we have not received yet.
CD of no, what PS?
Ramdul case number 33, 24 we have received.
CD of
30, Ramdul PS 32 oblique 24.
What? Huh?
Dharamtul.
Dharamtul is received. Send
And
back the CD. We will send it back. You are on interim bail, no? Will not retain the CD.
Okay.
Under which sections?
It is 118, 109, attempt to murder and lordship Devia's heart.
Send back the CD. Call for the CD of Dharamtul. Call for the up-to-date CD and also call for the CD of which case?
Ramdul PS case number 32 oblique 24.
I have to forward both the CDs positively on. Interim order shall remain in force till then.
When is it 20?
Because senior is in bereavement, no, I think it will take at least 1 month. So you send it back, we'll get the up-to-date CD.
Item 40.
Like,
This is a previous bail application. CD was called for here.
We have not received that case data. It is maybe internet.
CDS call for is not received, we should reminder, list the matter on. Interim order shall remain in force till then.
Oblige.
Item 41.
May I please? It is a pre-error bail application.
We have the CD.
So CD received, but we have required the injury report. Earlier occasion also injury report was called for, that is not up to date, but injury report is required.
Okay, here one of the petitioner has
Better
already
not
been.
to hurry.
Yes, already.
Last case is that they did not wait for injury report, we cancel the interim bail.
No,
What is the
but
point?
I am without interim.
Even then,
Okay, I am not pressing the this petition for petitioner number 1, but it has already been arrested. That may be reflected in the order.
it is submitted by learned counsel Mr.
M. Ahmed.
M. Ahmed that the petition number 1 has already been arrested and he is and he has not pressed for his bail. Full stop. The learned additional PP has submitted that CD is not up to date or what?
Injury report is required.
That CD is forwarded without the injury report call for the injury report, list the matter on.
Lordship,
Short date?
without interim.
Yeah, we'll keep the CD.
It's too long.
No, 2nd April লম্বা হৈ যাব কাৰণ CD to retain
26.
26 March, CD to be retained till then.
Item 44.
Yes, yes.
Is on interim lordship. As per my instruction, also he appeared and cooperated in the investigation. Look what my Danet can say. FIR, your lordship will find page 9.
You have the CD?
CD received, Lordship. He has been in time, Lordship. He has appeared and his statement is recorded.
But Mr. A. Ahmed, learned counsel for the petitioner, one petitioner.
One.
So and so who has filed his application under section 482 of the BN WS 2023 with prayer for pre-arrest bail as is apprehending arrest in connection with so and so PS case under so and so sections. The petitioner is apprehending arrest in against allegation of smuggling of Erica nuts.
No, lordship, it was some Erica nuts were stolen from a vehicle, lordship.
Or allegation of smuggling Erica nuts. How many kgs? 32,900 kgs of Erica nuts. Of smuggling 32,900 kgs of Erica nuts. It is submitted that by the order dated 5/2/2025, a coordinate bench of this court has granted the petitioner interim bail, full stop. Third, Mr. D.P. Goswami, learned edition PP Assam, who has submitted that the petitioner has appeared before the IO and he has cooperated with the investigation, full stop. I have scrutinized the case diary. The petitioner's statement is recorded by the IO. The petitioner has not violated any bail condition. The petitioner has cooperated with the investigation. Considering all aspects, considering all aspects, the interim order dated 5/2/2024-25 is hereby made absolute under the condition that the petitioner shall refrain from such activities with which is alleged, number 2, and he shall not leave the jurisdiction of the court. Full stop. On breach of any of the bail conditions, bail order shall stand automatically cancelled, sent back the city.
Obliged.
CD was called. CD receipt. My lord, in this case, my lord, FIR is at page 11. It is
Page?
Page 11.
11, yes.
My lord, it is a case of suicide as it appeared on the FIR. Allegation is that, my lord, the wife of the informant, my lord, there was a marriage solemnized about 14 years back. And the informant has got 2 daughters out of that wedlock. There was some illicit relationship between the accused and the wife. And ultimately, my lord, she committed suicide. And there was a village mall meeting, and in that meeting, petitioner was found guilty. And some warning was, my lord, made to him. In spite of that, my lord, on a particular date, it is on 30/11/2024, my lord, there was some telephonic conversation. And later on, she committed suicide. This is the allegation, my lord. Even if assuming that there is some illicit relationship, this
Do you
is
have
not,
anything, any material against him?
My lord, here, my lord, police, my lord,
Against Sahil Sarkar?
only Shahid
It's
Sarkar.
okay, it's okay. You.
there is, my lord, some, this is a telephonic, my lord, conversation that they have, my lord, police, my lord, from their, those conversation, police, my lord,
No physical
my lord.
instigation.
And other, my lord, parties there, one, the daughter,
They were
my
granted bail.
daughter was there, her statement they recorded,
Minor daughter.
my daughter.
Any materials under section 108?
108, my lord. So, my lord, it is very nascent stage, my lord. Investigation still going on, my lord. We have taken some, my lord, statement, recorded some statement.
Okay, let me see. (108) is abetment to commit suicide.
Yes,
right?
yes.
And any other sections?
Yes, 3 conspiracy.
Huh?
Conspiracy.
Conspiracy.
Section
Conspiracy and
3(5).
abatement.
Abatement.
108.
My lord, there is no-
I'm taking the wrong BNS. I think can be granted. Is there any inducement from his side?
Other than that, my lord, I have not,
You want to go to the CD?
my lord, no, I have done through that, my lord, but it is not also coming into my notice. Only they, my lord, submit one objection that I also have.
Who has submitted objection?
My lord, from the end of the police side.
Investigation. 4-5 witnesses have been examined,
Yeah,
but
that-
who will know anything about what is
I will
going
tell
on?
you the thing because my lord, in the FIR itself stated that only after that phone call that incident happened.
Our learned counsel, Mr. A.K. Prakash, for the petitioner Sahil Sotar.
Yes, my lord, yes.
Who has filed his application under section 482 of the.
And other, my lord, there are other two petitioners, they were granted interim bail. No, this is, I'm sorry, my lord. Yes, yes. Trial court, they are granted bail in trial. This is only for Sahil Sotar. Sorry.
Sahil Sotar, who has filed his application under section 482 of the BNWS 2023 with prayer for period as bail, as is apprehending arrest in connection with students of PS case under students of students. But Mr. K. Busha, learned HMPP Assam. Stop. I have considered the submissions at the bar with circumspection. They stop. The allegation against the petitioner is that he induced the victim to commit suicide. The victim is the informant's wife, and she has committed suicide in her matrimonial home.
Yes.
In a matrimonial home. Full stop. I have also scrutinized the case diary. The merits of this case are not brought to the fore. I have scrutinized, not brought to the fore, as this case is still under investigation. It appears that pre-arrest bail may be granted to the petitioner. First, I have considered the submission of the petitioner that he is willing to cooperate with the remaining part of the investigation and to abide by any stringent bail conditions if imposed upon him. In the event of his arrest, the petitioner shall be enlarged on bail of rupees 50,000 with a surety of like amount to the satisfaction of the arresting authority, under the condition that the petitioner shall appear before the IO within 1 week and cooperate with the investigation. Number 2, the petitioner shall not exercise threats to witnesses or try to influence them. The petitioner shall not leave the jurisdiction of the court without prior permission. On breach of any of the bail conditions, bail order shall stand cancelled automatically, sent by the CD. Mazan Bhairi Basun, considering the submissions at the bar liquidia and considering all aspects liquidia.
I'm obliged.
Item 49.
You have the CD?
My lord, 48 and 49 together, my lord. We received the CD, my lord.
What are not present, no? 48?
48 is mentioned.
course.
49, my lord, arising out of the same affair.
Same affair.
Same affair.
Petitioner is not represented today. CD is received. For the interest of justice, list this matter on 20.
My lord, until then, my lord, CD will be retained. Because
we have already called for a CD, no? CD to be retained till then. 1 week, yes.
May I please? Page 11 is the entire.
Well, here 2 CD was called from it.
2 CD in cross case is there.
No, we have received only 1 CD.
And our case was in first of point of time, Lordship. We have lost it immediately after the incident, when they have lost it after 5 days. And both sides received injuries.
Already
Lordship.
wanted, we will wait. Only 1 week. We'll return the CD and we'll wait
Both
for
sides sustained injuries, Lordship. Our person sustained injury on the head and their person on the eye.
CD of Dhikazuli PS case number
29424.
294 of oblique 2024 is received. CD to be retained.
29424 we have not received.
That is the loss by us.
29525 is received. 29524 is received. The other CD is not received. Retain the CD till the next date. Retain the CD till 24 March. Meanwhile, call for the CD of Dhikazuli PS case number 294 of 2024. Assam additional PP case. Cancellation হয় নেকি? Cancellation of bill. Passed over for the day, list the matter on.
Lordship, this is a 482 Lordship, AB, filed by the complaint, filed by the one Partha Das Lordship, which is page number 12 Lordship, page number 12. It starts from page number 16 Lordship. May I read Lordship? Lordship, one, the first party are the resident of the aforesaid locality are healthy and working persons. The first party and the second party are the persons of the same family and are brothers in relation and are living separately with their respective families. The second accused person is known to the first party. The scheduled land is Miyadi of the first party and have been paying the revenue by their own means. The below described scheduled land is Ismali Patta land in the below scheduled land and the name of the family members are incorporated. The second party, number one, had long back sold the entire land of his shares standing in the name of the deceased father of other person. Only the name of the deceased father remained in the patta. The second party number one has no right, title and authority over the scheduled land. He has no patta in his name, nor has any certified copy of government revenue paying receipt of any document. As such, the second party number one, without the knowledge of the first party and family members by way of village sold the land to the second party number two and handed over the possession. The second party number one, by taking huge amount of money from the second party number two, handed over the possession of the land to the second party number two. When the first party and the family members came to know about the incident, they went to the place of occurrence and when they say the incident, they uprooted the boundary fencing on 23 to 25. With the assistance of the family members, they reclaimed the land in their possession by erecting boundary walls and constructing houses. When the second party came to know about the incident, the second party on the night of 23 to 25, without the knowledge of the first party, caused severe damage by breaking down the newly constructed house. When the first party discovered the destruction on 24 to 25, they attempted to intervene the apprehending clash between the parties. The first party was constrained to lodge this complaint before your order. The second parties had caused significant damage by destructing the house by using sharp weapon. As such, doesn't exist. Presently, the second party armed with a sharp weapon are loitering to take in possession the below scheduled land. If resisted, it is apprehended that there is a serious threat of right. The second party are now known for their
Yes.
lordship. That is the only thing. Otherwise, this is a civil dispute, lordship. Because of that, the complaint has been filed before the superintendent of police, which is received and registered. That is 16C, lordship, as which is page number 17 as Bisana Charlie PS case number, which is in page number 17, lordship. On
All right, yes.
Seems kind of some kind of civil dispute.
Civil dispute, lordship.
Can be granted, no?
Yes,
I
lordship.
think so. These are all under 7 years. All these offenses?
All under 7 years.
Not all.
That one section I think is not above below 7 years.
Lordship, only the 336 fee, which is forgery, 7 years. And 351 3 is
All right. Third, Miss N. Narula.
M. Nirola.
Learned counsel for the petitioners. Brothers.
They are cousin brothers, yes. Family dispute.
But you'll have to abide by the strict conditions, huh?
Yes, Lord.
Learned counsel for the one petitioner only.
Yes, Lord.
Petitioner. Who has filed this application under section 482 of the BNWS 2023 with prayer for pre-arrest bail as he is apprehending arrest in connection with so and so PS case under so and so sections. Our learned additional PP Assam, Mr. R. Kochi, full stop. I have considered the submissions at the bar with circumspection. The allegation against the petitioner is that he fraudulently sold. He has sold the land fraudulently, no?
That is alleged, Lordship.
That he has fraudulently sold the land belonging to the informant, and thereafter he, with the help of the buyers, tried to dispossess the informant and dispossess the informants and full stop. It is further submitted that armed with weapons, the petitioner has been threatening the informant, and he has been trying to dispossess the informant with force. Full stop. It is submitted on behalf of the petitioner that a case that the petitioner has prayed, the petitioner, the informant has prayed for registration of a case under section 145/107 CRPC, which clearly reveals that this is a case of civil nature, taking the color of a criminal nature. Full stop. I have considered the submissions at the bar with circumspection. Stop. It appears that interim bail may be granted to the petitioner. Call for the CD. This is the matter on. Meanwhile, in the interim and in the event of his arrest, the petitioner shall be enlarged on bail of rupees 30,000 with a suitable surety of like amount to the satisfaction of the arresting authority under the condition number 1, that the petitioner shall not exercise threats to the complainant and the witnesses. Number 2, the petitioner shall appear before the IO within 1 week and cooperate with the investigation. Number 3, the petitioner shall appear before the IO on every fortnight till completion of investigation. Number 4, the petitioner shall refrain from such activities with which he is alleged. Number 5, the petitioner shall not leave the jurisdiction of the court without prior permission. On breach of any of the bail conditions, bail order shall stand automatically cancelled.
But it's a case, my lord, where Jimma has been rejected, my lord.
Jimma what?
Jimma page 19, my lord, for a once, my lord. 19, my lord. One Ultra T7 vehicle, my lord, and 21 grams of suspected petroleum product, my lord.
You'll have to hear the other side.
Other side, the prosecution.
Not the not.
No private party.
No. This is a petroleum product, isn't it?
The petroleum product, my lord.
Under which sections?
My lord, that's the thing, my lord. Now, if a lordship, my lord, for a once, my lord, before going, my lord, the rejection order is at page 40, my lord.
Page 40.
Page 40, my lord. 40.
We'll call for a report.
The report, I think, has been called.
Have you received a report?
Record in the record, I think it's available.
What report?
My lord, first of all, my lord, there is a legal submission, my lord. And if your lordship sees, my lord, the Caesar, my lord, that's why I pointed out, my lord, page 19, my lord, for again page 19, my lord. 19, my lord. Page 19, my lord. My lord, it is
Just a moment, I want a report. Submission of report. Yes, I have got it.
My lord.
Submission of report.
That was, yes.
It will be
That is the report, yes.
No, it will be like
That is a report. I have earlier occasion. I have
Gwalpara PS case number 139.
Yes, my lord.
For her. Which is fixed on or rejects her up to date case that you have to set cases. Report.
Same report, madam.
Whether these are petroleum products, it could not be ascertained.
No, my lord, that is the point, my lord.
It will
Wait, now, my lord, lordship will, well, that's why I am turning to my lord, page number 19 for a once, my lord. Again, my lord.
Let us wait for the report, FSL report.
No, that's why, my lord, whether FSL report is required or not, my lord. Page 19 for a once, my lord.
At least then we will need the LCR, at least.
No,
at least the LCR.
My lord, it's an illegal seizure, my lord. That's why I am submitting.
No,
That's what.
we'll need the LCR at least.
Not only one point, the legal submission, your lordship may accept it or not, my lord.
You want a stay, interim stay?
There is no interim stay, my lord, because I have purchased this material, my lord. It is lying there, my lord. And the police has no authority to seize this thing, my
এইটো আৰু এখন আছে কিহৰ হয় এইটো একে সেম না
lord. The next one is vehicle, my lord. There are two cases, my lord.
vehicle report এখন call at least vehicle will call for the report.
My lord, now whether the police can seize or not, my lord.
No, that we'll not get into all that.
Now that is the thing, my lord. Because, my lord, here lordship will see, my lord. That's why I'm pointing out the seizure, my lord. It has been seized by the sub-inspector, my lord, one sub-inspector. And the act says, my lord, sub-inspector cannot seize, my lord. He has no authority over this, my lord, this petroleum product.
This then we will have to dispose it of.
Your lordship may.
Let us call for the LCR.
LCR, my lord, there will be nothing, my lord. Only the
No, we will need the CD at least.
CD is available. CD is
But only the report was called for why during the investigation it was required or not for a further investigation. That is the report submitted by the IOR. So, my lord,
CD was called for.
only the report was called for, but along with the CD, CD is received. But regarding the CD, it is not.
Let me see the earlier orders. This petition under 482.
Correct.
Mr. K. Bosher has submitted that the report which was called for in connection with this case has been received. Let the report be a part of the case record.
My learned senior friend is arguing on the basis of the whether if ASI can seize the materials or not. Right?
Yes.
But this case was fixed for something else.
Well.
On the day, the learned counsel for the petitioner shall make a submission regarding maintainability of the instant petition.
Yes, I have written. I had a written submission, my lord. That
Maintainability of this petition.
Yes, maintainable. My lord, may I submit, my lord?
Yes.
My lord, the orders, my lord, of the court below, my lord, are of three kinds, my lord. Interlocutory order, final order, or intermediate order, my lord. So far, this order is concerned, my lord, it is passed in a, my lord, Jimma case, my lord. To my understanding, my lord, this is an intermediate order. So, my lord, the revision lies, my lord, in the instant case. Relying on the decision of the, my lord, two decision, my lord, Amarnath and Madhulemia case, my lord. That I have made a written submission that may be taken.
Yes. But you see, I am very hesitant to pass any order without the LCR. It is very difficult for me. I have already passed 2 orders in such cases without LCR.
My lord.
One was because the LCR was not called by after so many. There were so many orders that I couldn't track down, and LCR was not called, and it was fixed for hearing. So I had to dispose it of. And the other was I had called for the LCR of Nazira, and the LCR of Guwahati has come. So and it is very difficult for me. I personally cannot pass orders without the LCR. Maybe somebody else can, but for me it's very difficult.
So far, in the instant case, charge sheet has been not paid.
So then we'll keep the CD and then we'll pass a final order.
Yes, madam.
Then are you ready with the submission?
No. That regard, I have to go to it regarding the.
That is the law, my lord.
No, see, only one side it will be very difficult for me.
Then your lordship may fix day after tomorrow, my lord. We'll have a hearing, my lord, in this case.
Yes.
My lord.
Day after tomorrow?
Day after tomorrow, and the point, my lord, my learned friend, my lord, I'm
What
raising,
about the LCR? Oh, we have the CD.
I am raising, my lord, 2 points, my lord, whether the sub-inspector can seize the petroleum product and whether any license is required.
No,
my
no,
lord.
no, petroleum, I do not know anything
No, no,
about
that's
that.
the point, my lord.
Because here you see the said case is under investigation. I have sent reminder prayer to FSL Kahilipara, but due to non-production preparation of the FSL report, it is not to be collected. So until ascertaining the suspected petroleum products, still not ascertained.
That's the point, my lord. Whether the petroleum product which has been seized by the police officer is required to send to the FSL or not, my lord. But that's my case, my lord. It is not at all required to send to the FSL, my lord. They are required to send to the, my lord, controller or petroleum officer, my lord. No, my lord,
Yes,
FSL
yes,
is not at all
in
required.
that EC Act also.
Yes, my lord.
Yes.
I am
It is sent to another department. I know.
Yes, my lord.
They check whether it's a petroleum
Yes.
product or not.
So I will raise this
Yes.
point, my lord. Let him answer
Yes.
these queries, my lord. That much.
Okay, as agreed by learned counsel for both the sides, list this matter on first day.
My
Met previous. Here the petitioner is in custody, lordship, since 6/10/2022. And as on today, lordship, 2 years, 5 months, 11 days. Here, lordship, I have three folded submissions, lordship. First, lordship.
2 years, 5 months,
11 days.
11 days.
11. And here, lordship, I have three folded submissions. First submission is on the ground of delay. That prolonged incarceration is there. And second ground, lordship, that while arresting the petitioner, that in the arrest memo, lordship, that grounds were not mentioned. That lordship.
Now you will all mention that judgment now.
Lordship. And third ground is that, lordship, that seizure witnesses who were examined in the present case, they do not support the case of the prosecution, lordship. And in that regard, lordship, I will rely on a Supreme Court judgment which says that prolonged incarceration and the fact that the seizure witnesses did not support the case, Section 37 was diluted, lordship, because of Section 38. It is already there in the record, lordship, that Ankur Chaudhary case.
You have the judgment.
Look, Ankur Chaudhary, we have already given, that is in the.
Already lost it. Last question, I think.
Ankur Chaudhary.
Yes.
Page?
Page 3, lordship, may kindly say.
Page.
Lordship, got it.
Robi Prakash I have. Ankur Chaudhary.
Ankur Chaudhary.
No, I don't have Ankur Chaudhary's page.
Okay, I'm just giving that copy. Page 3.
Relating to what? Ankur Chaudhary's case?
Here, lordship, the seizure witnesses did not supported the prosecution case, and there was delay in the trial, that prolonged incarceration. Therefore, considering these two aspects, lordship, he was granted bail. Just reading paragraph page 3, lordship, may kindly see down below pagination is there. It starts with now on examination. Lordship, got it?
Yes.
Now on examination, the punch witnesses have not supported the case of prosecution. On facts, we are not inclined to consider the investigating officer as a punch witness. It is to observe that failure to conclude the trial within a reasonable time, resulting in prolonged incarceration, militates against the precious fundamental right guaranteed under Article 21 of the Constitution of India. And as such, constitutional liberty overriding the statutory embargo created under Section 37(1)(b) of the NDPS Act may, in such circumstances, be considered. So accordingly, he was granted bail, and he.
Okay.
And here also, in my case also, that PW 1, 2, and 3, lordship, they are CJR witness that I have enclosed here also. Lordship will find page 27 onward. They have not supported the prosecution case. Even they were declared hostile for them.
Okay.
And second, that ground Lordship, that results were
That
not.
judgment is given to me.
One is forbid protection.
No, we are presenting.
High Court already did already.
That grounds
I have
not
given
mentioned.
to High Court our coordinate two judgments, Lordship, that are discussed all the relevant judgments.
That justice have been to go.
Now, from one by Honorable Justice Midul Kumar Kolita and one by Honorable Mrs. Justice Malasri Nandi.
Not grounds are not mentioned.
Not, I have flag mark that arrest memo. I have flag mark in the record.
Which paragraph of Justice Midul Kolkata's judgment?
Elaborately discussed from paragraph 16 onward. All the Supreme Court judgments is quoted, and then your paragraph 40, paragraph 27, 28 regarding the finding.
Paragraph 15.
Paragraph 16 onward.
Paragraph 16 onwards.
Lord.
And that in para 11 that Bhyan Kumar's judgment is stated.
Lord.
That recent judgment.
Yes, that paragraph 24, your Lordship will find that Bhyan Kumar is quoted paragraph 24.
Okay.
Out of Lordship, 19 PW, 5 were examined.
I have got the certified copies on last occasion. Your Lordship granted us time to for that certified copy of that PW6 I have obtained.
How many witnesses? 6 witnesses.
6
have
witnesses examined out of 19. And 13 witnesses are yet to be examined.
And first framed on 3623.
What?
3623. First framed.
3623.
6.
36.
All right. I need some time, at least 1 week's time to pass this order. Anything else?
So this
Something I have flag mark also.
LCR, you have flag mark.
That results of order arrest memo, I have noted that flag mark there.
You have flag mark there as memo. Which page?
Blue flag mark is there in record.
Page, you know, at least. Do you remember the page number? We do not have any blue flag mark.
I will point it to the court master. Okay? I will point it to the court.
To point out to me, yet a bite of potato side. Yes, sir. Day to be after that.
Item 57.
May please, Lordship. Today is the 45 days, Lordship. The other co-accused already granted bail. Today is the 3 accused already granted bail by Session Das, Lordship.
Oh, he has been granted bail.
No others, Lordship.
Oh, accused. Why don't you withdraw this petition?
Lordship, one petitioner.
You have the CD or what?
Yes, I have the CD. Yes, sir. The length of detention, Lordship, the 5 accused are already granted bail.
You are behind bars for how many days?
45 days, sir.
Where's the CA? Where's the FIR?
FIR page 8, Lordship.
Page 8.
8.
Part, Mr.
Madam, here otherwise they are running a gag. They
That fraud.
Madam, similar to that, but they are not attacking, but they somehow they sought for vanilla, my lord, innocent person, mostly elderly and so they exchange the my lord, ATM card. Subsequently, my lord, they withdraw the money. He is one of the there are several others, so including him. They are running this gang.
And so pretend to earlier 2023 lordship, I arrested in the same yes lordship only first session lordship.
Not
the air
session,
statement,
there are
no recovery lordship.
There are recovery was made, not that ATM card which has been got by the government, but other ATM card of other persons. In fact, he also admitted that he has committed this thing along with other persons.
It's actually interesting. Other 5% already granted.
Yeah, habitual offender. In fact, all the CCTV, those CCTV which are there in the ATM.
This is AB or BA?
BA.
BA. 45 days, huh?
Yes. Those CCTV also for them.
Between BA number 533 lordship, the Honorable Court has granted bail.
I have granted bail.
No lordship, Honorable Das lordship PJ Vehicle lordship on 10th March.
The photographs is okay. The
The
CCTV.
length of detention of the accused person granted bail.
Our learned counsel, Mr.
Yeah,
N. Ahmed, for the petitioner. Lutfur Rahman alias Rocky, who has filed this application under section 483 of the BNWS 2023 with prayer for bail as he is behind bars since 1/2/2025 in connection with so and so PS case under so and so sections. Heard Mr. R. Kaushik, learned edition PP Assam, who has submitted that they are incriminating materials in the case diary along with what will be it? What is it called? CCTV footage. The allegation against the petitioner is that he is involved in fraudulently switching ATM cards from innocent citizens, innocent people trying to withdraw money from the ATM, and thereafter siphoning off the money of innocent people in this manner. I have also scrutinized the case diary. Indeed, there are incriminating materials in the case diary against the petitioner. I have considered the submission that the co-accused have already been enlarged on bail. I have also considered the submission that the petitioner is willing to cooperate with the remaining part of the investigation. Case number, what is the case number?
Bosista 42.
I do heavy additional PP objection disease this objection लिखला ना पिछो line to take हुमाई दिया तो it is also submitted that the petitioner works with a gang लिखी also continue for last of the petitioner is a local resident and he has pledged to cooperate abide by any stringent bail conditions if imposed upon him. Considering all aspects petition is allowed, the petitioner is enlarged on bail of rupees 30,000 with a total surety of like amount to the satisfaction of the
CGM Kamrup.
Why CGM Kamrup? CGM Kamrup, the police stations are divided with other along with other magistrates also, no? Why everybody has to go
Under
to
the
CGM Kamrup?
Under the civil judicial magistrate.
No, but Kamrup district, Kamrup Metro.
Metro.
There are so many police stations. There are other Elaka magistrates also.
Yes.
Why
divided.
everybody should go to the CJM? CJM has lot of work, isn't it?
Jurisdictional magistrate,
To the jurisdictional court, stroke Elaka magistrate, that will be better. Under the condition that the petitioner shall appear before the IO on every fortnight till completion of investigation. Number 2, the petitioner shall refrain from such activities with which he is alleged. Number 3, the petitioner shall not leave the jurisdiction of the court without prior permission. He is from here.
Yes.
On breach of any of the bail conditions, bail order shall automatically stand cancelled, send back the CD.
Biplab Lordship.
Readings complete.
But on last occasion, Lordship has issued notice and directed us to obtain a status report. I have received the report.
Relating to what?
Lord, if in brief I can just place the fact. Lord, the petitioners before your lordships are the manager and the owner of a tea garden situated at Gwalpara.
But this is for orders only?
Yes,
Milord,
orders for possibly.
on the last occasion, Milord, there is a direction by this honorable court that an interim prayer will be considered on today, Milord. Because the
Do I have time?
will not be, it's not very, Milord,
In fact, my
facts are not that much elaborate,
my
Milord.
report is Milord, indicative, Milord. The steps taken by the police have been indicated. Milord, kindly see, 2 cases have been already registered. They have investigated. One earlier affidavit, Milord, FIR they have filed on 6/1. Milord, after investigation in that FIR, in fact, my report also says, Milord, and I'm reading this second. Kindly see the second panel. Second panel. Second report. So in connection with the aforesaid incident on 6/1/2025, on 6:27 p.m., the manager Diganta Burman filed an FIR at Rongzuli PS stating that during the agitation on 28/12/24, the manager, his father, and management staff were physically assaulted by the laborers, causing grievous injuries to their person, and also committed robbery and extorted a sum of ₹9 lakh and a gold chain from the manager Diganta Burman by pointing a gun towards his head. Hence, case has been registered at Rongzuli PS by Rongzuli PS case number 1 of 2025, and so was entrusted to investigate the case. During the investigation, this is important. During the investigation, IO visited the place of occurrence, viewed the sketch map of the PO, and recorded the statement of the complainant and other available witnesses. That is, personal security of the Bagan management, the female management employee under Section 180 of BNSS 2023. In the statement of the personal security, it is stated that they have not seen anyone carrying arms and assaulting the manager. The female management staff also stated that they have not seen anyone assaulting the manager. That is the complainant or carrying any weapon or arm. The CCTV footage of the area could not be collected as the CCTV was not functioning. From the statement of all witnesses, it is learned that only the female laborers have entered into the management's residential area, and there is no evidence of assault or extortion by pointing a gun at Diganta Burman was found. The victims were medically examined and the medical reports were also collected. The attending medical officer mentioned in the report that there is no external injury seen on the body of the victim. After completion of the investigation on the incident case was submitted in FIR. Now, there are 2 instances, 2 FIRs were filed. The first FIR is that the physical assault, extortion of money, and on a gunpoint. In fact, the witnesses of the statement of the personal security of that manager and the female staff, they said that they have not seen. So the FIR file, the allegations made is not supported. Is
Rongzuli PS case number 1 of 25 is ended in FIR.
In FIR. Now, second instance is there, Lord. In the meantime, on 4/1/2025, a meeting was held, and this is the thing. It was held and presided by the ADC Gwalpara with the garden workers, and lockout notice was withdrawn by the management. The garden work resumed on 6/1/2025, but on 10/1/2025, the manager Diganta Burman, son of so-and-so, Simoltola Tea State Manager PS Rongzuli Gwalpara, submitted an Azahar at Rongzuli PS sitting inter there. On 10/1/2025, this is the second FIR, at around 4:30 p.m., a mob consisting of 18 people attacked and assaulted the complainant and his staff, Ratul Talukdar. The handshake case has been registered as at Rongzuli PS by Rongzuli PS case number 3 of 2025. During investigation, it was found that in the evening on 10/1/2025, some of the workers involved in an argument with the manager regarding their wages not being paid by the management, which later resulted in a gathering of around 500 to 700 laborers of the tea state, causing assault to one of the accountants named Ratul Talukar, not to the manager. The allegation is made by that manager was there. But the situation was controlled by the staff of Simultola Outpost, wrongfully PS, accompanied by the circle officer wrongfully later on. Both the complainant and victim were sent to wrongfully PPHC for medical treatment, but the doctor referred them to Guwahati Medical College and Hospital for better treatment. I have visited the place of occurrence, previous draft sketch map of the place of occurrence. I has interrogated 8 FIR named accused persons. They said in the petition alleged that no action has been taken against the FIR named accused person, and their statements were recorded under section 12. So no evidence found against them so far. Hence, they were released as per procedure under BNSS. The statement of 2 security guards, namely Rajiv Das and Dhruvajuti Das, have been recorded under section 180 of BNSS. They stated that they have seen a large crowd approaching the management office, but they could not ascertain who have assaulted the manager Bormon, manager Diganta Bormon, and staff Ratul Talukar. One assistant manager, namely Silti Bora, victim, stated that she has not seen anyone assaulting the manager and his staff. Moreover, no one have assaulted her and she did not have any injuries. One more victim, namely Ratul Talukar, could not be examined as he is not cooperating. The injury reports are yet to be collected. Moreover, the case is pending for finding more evidence and an eyewitness. The investigation is not going. At this stage, these are the steps they have taken. They considering the seriousness of the issue, because repeatedly they are agitating, some complaints are being coming up. The issue of additional the additional superintendent of police crime Gwalpara has been entrusted to personally supervise both the cases for speedy and effective investigation. The regular patrolling and area domination are being carried out in the Simultola Bagan and to maintain general law and order and peace. Further, they have also communicated. A communication has been made through ADC Gwalpara by this office by memo number so dated 29/1/2025 with a copy to the manager Simultola for deployment of home guards as part of permanent security arrangement to ensure effective security measure in the guard. Their basic concern in the petition case is that number one, that they have filed laws FIR, no action has been taken by the police. I have the report is indicating what steps they have taken. First FIR, they found that the allegation is that he was assaulted and some money has been on gunpoint, some money has been extorted, and those allegations are there. But the statements recorded by during investigation by police shows that there is nothing. In fact, their witnesses said the personal security of the management said that they have not seen somebody assaulted. And the second case, only the accountant Ratul Talukar, he was assaulted, not the manager. So and the next page, can you see? This is the later one. The regular patrolling and all these things have been given. But while approaching the honorable court under 226, praying for an interim order, they have to come with a clean hand. Now, kindly see what they have prayed in the interim. Yes. Kindly come to page number 52. 52 of the petition, 52 of the 51, the prayer start, the prayer portion starts. In fact, I'll not take your lordship to the main prayer. Interim, they have said 8. D, page 52, D. Pass an interim order to monitor the progress of investigation carried out in respect of wrongfully PS number 1 and wrongfully PS number 3. My report is very clear. My status report is very clear.
Yes.
So
Yes,
no further order is required at this stage in my
Lord.
recollection. And the second player, kindly see just the second player E.
Yes.
E, my lord. They said that the respondent number 4, they pass a direction upon the respondent number 4 to submit a monthly progress report before this honorable court till the investigation of the wrongfully PS case number 1 and wrongfully PS case number 3 are complete of 2020/25 are complete. 1 we have already submitted. 3 the report is we have not necessary, definitely my lord, as per law, whatever step is required, my lord, police will definitely take. And at this stage, my lord, no further interim order is required. Because
I don't think so. Interim order is
investigation is
required.
Lordship.
I don't think so. Interim order is required.
Lordship haven't heard me, my lord. Lordship will kindly appreciate. He placed some papers, my lord. I don't have any access to those papers, my lord. Firstly, my lord, Lordship, he has given one, my lord, I am not denying his whatever status he has got, my lord. Fine. My lord, here there are two parts.
One has ended in final report.
So, no, I'm not on that, my lord. The entire thing has got two parts. One is to take action in pursuance to FIR, whatever investigation they take. Also, will kindly appreciate one thing. From last year itself, from 2nd December, I think it's 2nd December, we are unable to enter into our tea garden because of this repeated two incident, my lord. First incident, my lord, if he has investigated something, my lord, whether the accountant was assaulted or the manager was assaulted, it's not a big factor, my lord. But the factor is someone has assaulted, my lord, by the laborers. Now, so far as investigation is concerned, you take whatever measures, you do your part. I am here before your lordships with the prayer to give immediate, my lord, protection to the staff of the garden members, staff of the garden, so that they can at least enter. From December onwards, my lord, we are unable to get into our garden. I'll just place the facts before your lordship. So far as investigation is concerned, it will take its own course. And I am before your lordships with a grievance that the state is not taking action. State is not taking action with regard to investigation as well as giving protection.
You
Now,
have
this
all
is
the
a tea garden.
respondents.
for 1 to 9. I'm
For
appealing
1
for
to 9.
1 to 9.
This is a tea garden, Milo. This is an industry. So we are entitled to get protection from the state. The entire thing originated. I'll just take.
No, you see, there's one letter also from the ADC, I think so, to the superintendent of police
Milord, such
regarding
letter-
arrangement of security to the.
I have also annexed such letter wherein the labor commissioner written to all the officers, SP and all, to give police protection. That was also not given, my lord. This, I'll just show.
We're just calling for the status. Let's
Sorry,
see if any protection has been provided. You are asking for
what I am asking at
security
this
so
stage.
that the garden
Exactly.
may
Lordship will
function.
kindly see, because there are 25 or 24 odd laborers who are creating all this trouble. All laborers are not.
Yeah.
There are more than 1,000 laborers are there, my lord. So these 25 person are creating havoc, because of which we are unable to enter the tea garden.
Can
If
you
we
give
cannot,
a status on the next day if any security is provided so that the tea garden can function?
what purpose will be served? That is my concern, my lord. If you don't give us security, if we cannot, my lord, today morning I have taken instruction whether you can enter. They said we cannot enter, sir. There is no security. Why should I, my lord, say false submission, make false submission before this court? So if they have done so many things, my lord, why we are not able to enter? Lordship will kindly appreciate for this 20-25%, those 700 or 1,000 laborers who wants to work and earn their wages,
No, but
they'll suffer.
this letter is the last date was fixed on. Just let me see. 10/3.
10/3. Yes.
So this letter was given to the SP Gwalpara on 29/1. 29/1.
January. January.
I have received the. I have
whole letter.
Nothing to laugh, Mala. We are before the.
No.
before the honorable court, Mala.
No.
I have received the report.
My friend should not make personal comment. I am laughing instinctively because when I filed this writ petition with a prayer seeking protection from this court, my friend is placing an instruction of January saying that there was a direction in January to give protection and we are protected, my lord. We are in the March also we are protected by virtue of that January order.
My
lord, I am grateful.
my lord, I have submitted the status report of 15th of March 2025. Number one. And the writ petition has been projected. My lord, this is a writ petition criminal. Kindly see, my lord, this is a writ petition. That is why this is not a regular writ petition, my lord. And an honorable court has granted me 1 week time for the report. Kindly see, their writ petition basically is for inaction or refusal on the part of the police authorities in failing and or to refusing to take any action.
Yes.
2 FIRs are there. I have placed in my report. Report is very clear that one FIR allegations are not the evidences collected by the police during investigation doesn't support the allegation in the complaint. Second FIR investigation is going on. So far the investigation, the statement evidences they have collected, kindly logical see.
Yes.
This is the report of the police. This is the report of the central SP. If it is not believed, as my learned friend has not said, but this is not a regular repetition that he's claiming.
There is no question of disbelieving my brother's report, my lord. There is no question. What I am on is that, my lord, my brother also failed to appreciate me. What I am on is that so far as investigation against the accused person is concerned, that will take its own course. But so far as the protection of the staff of the tea garden is concerned, there has to be some
drawn the attention only towards 2 prayers.
Prayer B, my friend is not reading, my lord.
No, I have
Prayer B, I have made
in prayer.
1 second. I have in prayer B, my lord, I have made categorical prayer. Issue a writ of mandamus commanding the respondent number so and so, their man, agent, and subordinate to forthwith provide adequate security to the petitioner number 1 company by deputing adequate police, permanent police personnel. So my prayer at this stage before your lordship is not that whatever what action is taken against the accused person, kindly give protection to
This
us.
is prayer numbers
B. Page 51. If my friend is heading to a technicality that no specific prayer, then, my lord, I have already filed an IA. Lordship can take up that IA, my lord, wherein I have made specific prayer. Prayer B is before your lordships, my lord. So this both things should not be clubbed together, my lord. At this stage, my lord, the situation demands that there has to be immediate police protection, armed police protection to the staff so that we can enter the tea garden and we can run. My lord, that is not before your lordships, my lord. We have filed last week, but it has not come in along with the case file, my lord. Lordship can, if my friends, my lord, urges this ground, that technical ground that there is no specific prayer, then my lord can have this matter on Wednesday along with the IA, my lord. So that will solve the purpose. My friend is...
No, he has not submitted that there is no specific
No,
prayer.
my friend is submitting that my interim prayer is with regard to taking of investigation. But I also made an interim prayer, concerning the main prayer. That your lordship will find at page 52.
Yes, I have gone through it.
Yes, issue ad interim orders in terms of the prayers above. Page 53, my lord. So, if my friend wants a specific prayer, my lord, I have already filed an IA. But that is not the issue, my lord. Every day's delay is creating a panicky situation out there, my lord. We cannot fine against 1,000 laborers, my lord. And at the same time, the garden has to run.
What is your IA about?
IA, my lord, it's a 2-page IA. My friend, my lord, on the last occasion also, he made this submission that there is no specific prayer. So as an abandoned caution, my lord, I have filed the IA giving specific prayer. Nothing more than that. Only 2-page IA, my lord. This is.
Okay, we'll hear it along with the IA then.
Wednesday, my lord, will take up.
Wednesday won't be possible. On Thursday.
Thursday. My lord, can it be on Friday, my lord? Or
Friday? Yes, on Friday.
yes. 21st.
Learned Counsel
My lord,
Mr. H.K.
only my humble prayer is that, my lord, if this matter should not be, my lord, appreciated that we are only for, my lord, against action against the accused person. There is a larger aspect to the entire matter.
In WP
That-
criminal, WP criminal, it will not come. This is not a writ petition civil. This is a writ petition criminal. And showing urgency as regard inaction of the police, you have approached this honorable court and then writ petition criminal. That is why, my lord, I have made my. This is not a writ petition civil. No prayer has been made against the district commissioner. Against if the law and order situation is there, where you have made the deputy commissioner as a party, where is the law and order situation you have made prayer against the deputy?
There are prayers, my lord.
No.
There are prayers.
Kindly come to page 51. Prayer
There
number
are
two.
prayers.
Prayer number 2. my lord, kindly come.
That is why he has submitted an IA. Let us take up the IA.
Yes, ma'am.
On
Proxy will
Friday.
take up the eye.
Prayer number 2 to the mandamus commanding the response number 1, 2, 4, and 5. The deputy commissioner is the deputy commissioner is not party. My lord. Response number 3. No prayer has been made.
Let, let us be, my lord, a bit elaborate now in 21st century, my lord.
No,
We should not confine. We should not, my lord. This is a responsibility of the state to give protection to the staff of the tea garden, my lord. It's a whoever is the respondent, my lord. My lord, state should come up. Yes, you are running a tea garden. You do your work properly. We'll give protection.
So that
Then why represent criminal? Why not represent civil? Then why this category?
Let my learned brother make the objection.
So
my lord.
that,
Then Proxy will take up the eye.
DC number 3 has not been mentioned. This is what you're saying. But in the prayer, number 3 has not been mentioned.
No, my respectful position. Look, writ petition civil seeking mandamus, it is well under. Writ petition criminal, my lord, against the police action, police inaction basically he has. And our response to that is that we have already investigated 2 cases are there. We have investigated. This is the status. Where is the question of passing an mandamus in this case? That is what
Writ jurisdiction is extremely large. my lord.
that is true.
Writ jurisdiction is not confined to such, my lord, any technicalities, my lord. When the people or the my lord, the citizen of this country will approach this court that this is the problem, state is not responding. Lordship will definitely, my lord, come in rescue to those persons, my lord. And here, my lord, I am asking within the purview of law. I am asking within the purview of law. But if the stand of the state is like that, no, do whatever you do, we will not give you protection. You close your tea garden, then fine, my lord. What option I have? What option I have? If the stand of this, he is objecting. The state council should have come up with the stand that you don't worry, we'll give you protection. But here it's diametrically opposite stand is coming. That's better, my lord, for the state.
Well, in that
It will.
there will be no submission from the respondent side. As
Not respondent side doesn't mean always objection. I have also appeared for the respondents, my lord, in many cases.
These things
It doesn't mean always an objection by the respondents, my lord. There are issues which is in the interest of larger public, my lord.
Learned Counsel Mr. H.K. Das is present on behalf of the petitioner. Learned Senior Government Advocate Mr. Nath, no? D. Nath. D. Nath is present for the respondent number 1 to 9. 9. It is submitted full stop by the Learned Counsel for the petitioner that an interlocutory application has been filed. Stop. Ready to place the interlocutory application with this record. Place this matter on 21st March.
Fine.
Into Herigo Diba.
Item 59. Deeply obliged. The interim order will be considered on that.
Yes. Prayer for interim order will be considered on that. Well, not required. It will be
Otherwise,
brought on
also
the
IA will be there before your lordship, my lord. Much obliged.
May I please your lordship? Your lordship, this is an IA. It was filed for implementing the necessary parties. At the time of filing of the anticipatory bail, sections of POCSO were not attracted. Later on, the report came that POCSO is also attracted.
Okay.
Therefore,
All
IA
right,
to
all
implement the necessary parties.
Our Learned Counsel Mr. I.A. Lihu, huh?
EL also.
Huh?
EL also.
A.R. Losco.
TA.
T.A. Losco for the applicant Mujibur Rahman, who has filed this application under section application for amendment of necessary for amendment and to implead necessary parties in AB in case number AB 27 of 2025. First of it is submitted that earlier the POSCO Act was not included, and then the informant
CD case, where it is been mentioned that POCSO is attracted.
the
CD once came,
informant was not made a necessary
not
party.
made necessary.
Jana Begum is informant. No?
Informant.
Informant was not made a necessary party in this case. So now, after submission of in the course of investigation,
Yes.
in the course of investigation, POSCO Act has been added, and the informant stroke respondent number 2 is to be liquidated. Informant is to be made a party as respondent number 2 in AB number 27 of 2025. Third, Mr. R. Kaushik, learned edition PP Assam, Pusta. Considering the submissions at the bar, the opposite party stroke respondent number 2, the informant is the informant. She is informant, are you sure? The informant is arrayed as respondent number 2 in is allowed to be arrayed as respondent number 2 in AB number 27 of 2025. In terms of the above observation, this application stands disposed of. CA to দিয়া আছে নি লগতে এইটো লিখি দিয়া ডিসপোজ অফৰ আগত লিখি দিয়া না এইটো লিখি দিয়া the applicant to file the amended cost type. এইটো AB to লিখি দিয়া list this matter on when do you want.
Your Lordship, on 7th April, by that time, all steps also will be taken.
আৰু হেৰি AB 27 of 2025. Meanwhile, call for the case diary. Issue notice to the informant. No, first you'll have to mention. First you'll have to file the petition.
We'll take steps and mention again, and then.
I think you have to file the amended petition first. So we'll list this matter now. In a short date, we'll list this matter. You inform CDTD logo nalai, passes steps of kota likhibo nalai. AB 27 of 2025 likhite, both the parties are represented. List this matter on short date at area. You then file the amended post.
Much obliged.
আৰু কিবা আছে নেকি?